Appeal is dismissed. Item 11. Impugned judgment is set aside. Appellant should immediately be set free from judicial custody. Yes, Mr. Das.
Yes, my lord, there is one debt reference. Debt reference. Item three.
Yes,
My lord, I am an amicus curiae, but I went and I have seen that I am an advocate general of the state
Uh-huh.
of Mizoram. I think it will not be proper
okay.
because the AG of a particular state, there is also one state.
Ah.
So being only a senior advocate, my lord, as per direction of Supreme Court, amicus curiae should be appointed as a senior counsel should be appointed. So I thought that, my lord, I have a bit of hesitation appearing in this case. My lord.
Okay.
I'm appearing for the appellant.
So we'll have to appoint somebody else. Or
As a
no,
senior-
or is there a?
Your lordship has to appoint as a senior counsel.
There is a panel actually.
Panel.
There are 5 senior councillors. Named in the list. Your name is there.
There are 5, I think. left.
Yes. Or Kumar Das is there, Mr.
Arup Kumar Das. Okay. we will-
Anup Kumar.
Anup Kumar.
Anup. You want Anup?
Teacher Mahanta.
The council who appeared for Hemaji case.
Yesterday,
Okay,
he
okay.
appeared.
Okay. Yes, senior counsel.
He's a senior counsel.
Okay, right. Anup Kumar.
Fine.
Yes, we go.
वो पेपर को कैसे माना दो तो किसी ने पी लिया होता
Mr. Anup Kumar, that's okay. No, we want your assistance on this.
Because apart from these 5, lordship can appoint others also.
No, no,
There is
but we will go as per the list.
Then Mr. Anup Kumar, Mr. Tonma Mohanta, or Mr.
No, which one do you think would be?
Other councils are too busy.
Okay, so Anup Kumar, okay, right.
Because my lord,
Okay.
Mr. K. Agarwal is also there, but he already has 2 matters.
Okay,
That I know.
Mr. Anup Kumar, that, right. Mr. D Das, amicus curiae. Makes a submission that as is the Advocate General for the state of Mizoram, he has some hesitancy in appearing in the matter. In view of the above submission made by Mr. D Das, his name may be struck off as the amicus curiae, and in his place, the Anup Kumar Das, senior advocate, will be appointed is appointed the amicus curiae. So for about the paper book, give it
I
to
have got a
you.
paper book. I can just hand over the paper book. to
Mr. D Das shall hand over the paper book to Mr. Anup Kumar Das during the course of the day. Release the matter after 2 weeks. I think we need some time at least.
It's given in the Supreme Court judgment, at least 2 weeks should be given to the senior council.
Okay.
He has
I have made
prepared rather.
I have prepared a flag mark also. But I thought that sometimes it may happen that in Mizoram, some case like this, it goes to apex court. He is a senior, who is the advocate general. So I thought that I should recuse myself in this. particular
yes.
case. Planification matter also I find sometimes difficult to appear. Some appears in for state of Assam against. Because I am in AG, I have to defend my state there.
And lot of land acquisition matters.
That's why, that's right. And that's. I'm deeply of this.
All right.
Before my lord starts, I have given that Hemaji's write-up.
We got.
Lordship. Because yesterday I already got a phone call from the paper authority, from newspaper persons, and asking about the case, Assam Tribune. And so.
That's what, this case is going to come
big
out in
news.
the news, either way.
Either way. That is why Lordship will just jot down my contentions, then whatever happens, happens. Because.
We will jot down your conditions, but we are going to be in the probably in the
No,
limelight. which we-
Lordship, nobody can question. That nobody can question.
Which.
For Supreme Court, I'm saying if they go to the Honorable Supreme Court,
Yes.
then my contentions will be there.
Okay,
Mr. V. Prasad is not well at all because there is a Pathar matter. We were supposed to give.
yes, you're supposed to give.
Haha.
You
We,
brought,
we got it.
You give.
Bhuya has also got it. But he is really not well. So
that is a different issue. We'll adjourn the matter. But then in the meantime, if you can give us your submission so that we are. So that we can,
in fact, one has been called, so
no, we'll just do 12 first.
Ah.
Just 1 minute, huh? We'll just do 12.
I
Item
did not, I did not get any Supreme Court judgments. So perhaps Miss Bhuya has got it.
I'll try to, because yesterday also I gave a
Ah.
submission.
Okay.
This citation I've already given once to refer to your
What
lordship.
is that?
This is not clear, while your lordship was sitting court number 5.
Okay.
There regarding the non-production of certain exhibits before the court.
What does it say?
Lordship, this criminal revision 33/93, Guwahati High Court judgment, single bench, para 9, may I read it,
Yes,
Lordship? Mr. Mojumdar also raised it's a matter relating to your lordship, the arms act, my lord.
Ah.
Mr. Mojumdar also raised the grievances on the ground that no sanction for prosecution of the accused person has been produced in the case before the trial court, and as such, the conviction of the revision petitioner cannot be sustained for non-compliance of the mandatory provision of section 39 of the Arms Act. There is no doubt that sanction for prosecution is a precondition for initiation of a proceeding under section 225(1)(a) of the Arms Act. The judgment in appeal passed by the learned session judge Hailakandi indicates that learned session judge could trace out the sanction in the connected file, and therefore he was satisfied the sanction as required under the law was duly accorded. But in a criminal trial, an accused has a right to challenge the legality and validity of the sanction accorded, and as such, he is entitled to cross-examine the prosecution witnesses on the point. This document, which has been placed before me during the course of argument, was not tendered in evidence before the trial court, and obviously it was not brought to the notice of the accused in order to afford him an opportunity to cross-examine the prosecution witnesses on this point. This document is very much essential for the purpose of successful prosecution, and it ought to have been tendered in evidence with due opportunity to the accused to assail it during the course of cross-examination of the prosecution witnesses. In my opinion, it was completely against the principle of criminal jurisprudence to take note of the sanction which is lying in the connected file as an effective document to hold that the prosecution was launched after obtaining sanction as part. So it was not.
Exhibited.
Yes, this is the one. And one more judgment.
Judgment of the single bench of this court.
Lordship?
Judgment of the single bench of this.
Yes,
Let us see the judgment.
Lordship. Well, I'll give the Xerox copy. And one more judgment, 2006, 10 SCC 157.
2006,
10 SCC 157.
10 SCC.
157.
Yes.
Para 12, my lord.
Para 12.
Yes. I'll read it slowly.
Yes.
Submission of Mr. Krishnamurthy that another for information report was also lodged earlier is based only a suggestion made to PW10. PW10 in his deposition categorically denied that even before lodging the complaint, Exhibit P1, another complaint was lodged at Balati Police Station. It is true that a learned trial judge has recorded a contention raised on behalf of the accused that, despite an application having been filed by the accused, the prosecution had failed to produce case diary and general diary relating to the date of occurrence of Balati Police Station. When, however, questioned, the learned counsel could not point out from the records of the case that any such application was filed by the accused or any order had been passed by the learned trial judge calling for the general diary from the police station. I have not gone through the record as regards the same, whether an application was filed by the accused appellant regarding your lordship and what order learned trial court has passed regarding non-production of the case diary and lordship as a IO did not appear before the learned court below. The question of drawing an adverse inference against the prosecution for non-production of the case diary or the general diary would have arisen had the court passed an order being satisfied that the prosecution intended to suppress some facts.
What do you mean by general diary?
GD entry is
GD.
yes,
GD.
GD diary, GD entry. Some facts which your lordship may kindly have a note, my lord.
But how does this have any relevance? This is only with regard to
Exhibit.
case diary and GD.
Whatever
It's
may
not
be,
with
now they
regard
have
to-
taken a plea that they have not exhibited the document, whether they have filed one application before a learned trial court. That it has caused prejudice to them because the non-production of the case diary, non-exhibition of the FIR. So my respectful submission is that when the prosecution could stand on its own legs and they could produce the relevant witnesses, more particularly 3 witnesses, my lord, 2 are child witnesses, 1 is the eyewitness, then and there is no contradiction to that effect that they did not see the place, date of occurrence, my lord. So lordship, as the IO was not examined, your lordship, as the FIR was not produced, it might not have caused prejudice to the accused appeal. But your lordship,
This is with regard to CD and GD,
yes,
which is really not relevant that much. Because as we all know, the case usually starts from, okay, GD sometimes, but basically from the FIR.
FIR,
And actually there is a division bench judgment as pointed out earlier.
yes,
Which was with regard to the 302 and Arms Act.
yes,
And the court of the deputy commissioner had convicted them on the said charges. Now, it went up to the High Court as deputy commissioner's order has to be confirmed by the High Court. And during the reference before the High Court, the counsel, Mizoram case, the counsel for the accused persons stated that no FIR, PME, charge sheet, inquest report, nothing was exhibited. The division bench then held that all the documents that are relevant for the prosecution case has to be exhibited.
so I have given, lordship has come to a finding that it has caused prejudice because of the,
No. I'm not on prejudice or not. The
My lord.
problem is this court,
my lord,
Guwahati High Court,
my lord,
another division bench has already passed an order
yes.
that it has to be exhibited.
Then Jahira Habibullah, it may be remanded back.
No, but then we want some Supreme Court judgment. Yes, so clear. You couldn't get.
Justice Mizoram case.
Yes, we have got it. We have got it.
Is there, Mano Varma?
Justice C.R. Sharma and Justice
C.K. Mushari.
Mishari.
Yes. And of course, there I think they have remanded it back.
Yes, it was remanded back.
No
Yeah.
documents were
No,
exhibited.
it can be remanded back under 391.
Yes,
Yeah.
yes, 391. Okay, lordship has this already because there only case there where I could find that so many documents were not exhibited. And there are other cases, lordship will get, of course, there is Justice Ansari's judgment. Birsha Kumari versus State of Assam. There also GD entry was not exhibited. And on that context, it was remanded back. Because case started with the GD entry and Honorable Justice Ansari said that it should have been remanded, cannot. Because it should have been placed to the accused persons to get an answer from them.
So what do? We can dispose it off or we wait for him.
Lordship may dispose, but no benefit should be given to the.
No, what benefit can be
Yes.
given? No benefit can be.
And there are Chhattisgarh judgment also where sanction order was not exhibited. And it was remanded. Sanction order under the Arms Act was not exhibited. And then the conviction on the Arms Act was set aside. Then there was Gujarat
Just a
decision.
minute. Just a minute.
Lordship, I have sent those mails
Send those mails to whom?
to the court, the judgment, the entire judgment
Yes,
itself.
no.
The Guwahati High Court judgment, this is 2013 4 GLT.
Can you give us? Is
Ha,
it
ha,
long?
ha.
Is it long judgments or short
No,
judgments?
no, not very long.
Ah.
Perhaps that Mizoram judgment will not be
I
required.
have got the Mizoram judgment.
That she can
That-
if,
that-
take out
we are bound by the judgment
Huh.
unless we take a differing view. And to take a differing view, you'd have to show us some other judgment.
I couldn't find any Supreme Court judgment.
Good find.
Only one that Shashikala judgment is there where the documents were not exhibited, but it is not during trial. It was after the charge sheet was filed. That Shashikala judgment, I don't think so that would be relevant in the purpose because there also documents were not exhibited. Lordship can see it once and send it.
I'm not getting your argument. What do you mean, not exhibited after charge sheet?
But they have to
Can
be.
it be exhibited prior to charge sheet?
This is what even I couldn't understand because under 207, the documents has to be given to them.
Correct.
And while giving, perhaps they were not given the documents. They had made an application to see and mark it.
Okay, so it was not part of the charge sheet.
No, it was not perhaps part of the charge sheet.
So then they could not have used it. They could not, there's no question of exhibiting then.
There's no question of exhibiting at that point of time. But then it was written like that. I'll have to again go through or I'll give that to
Give it to
2022.
us, we can go through. Also.
Huh.
Is it a long judgment?
It's little
Pretty
long.
long.
Shashikala's judgment. It's a PC Act,
Hmm.
Prevention of Corruption Act.
Can you give us the citation?
I'll give
Go
one.
through.
I'll give none anyway. But I'll give.
Then what do we do? Would it be proper to dispose of in his absence? We have not said partnered also.
Friday.
Can we-
Friday evening's presence order.
Okay, right.
Fixed another date.
As the learned counsel for the appellant, the learned amicus curiae, as the learned amicus curiae is absent due to illness, as submitted by the additional PP, lists the matter on Friday.
Not. These four judgments, Lordship can see. But one judgment that I said that was in respect of CPC, where document was not exhibited, but in certain cases exceptions can be made, it is said. This is by Guwahati High Court only.
That is Friday, this is CRPC.
This is criminal. But I've seen the Supreme Court also taking recourse to CPC while dealing with this.
Yes, they are judgments,
Yes.
no doubt about it. But then we don't, I don't know. We want something more specific.
And here is a case where so many documents, no, not one was exhibited. So
Similar as in the Mizoram
Mizoram case, yes.
cases, there was nothing was exhibited.
Nothing was Panchnama and nothing was exhibited.
In our case, PM report also was not exhibited.
Out here also nothing is
Here also,
exhibited.
sir.
Zero.
There,
In that case also zero, out here also zero.
FIR,
Ditto on the
FIR, search list, Caesar list, inquest report, medical report, postmortem, nothing was exhibited.
So, and there also case was under 302.
302.
Here also 302.
Mm.
What
Red.
more do you want?
Red bid 149. No, 34,
34.
34 and 384. And Arms Act.
384, they were not convicted.
384 not convicted. But it's written.
Only under 302 and I think 302, 34 and Arms Act.
These are which judgments Lordship is holding?
This is Guwahati High Court, Bircha Kurmi
Acha,
versus State of Assam.
This is paragraph, Lordship will go to paragraph 18.
Okay.
GD entry was not exhibited.
Okay. Then DB entry.
Then Chhattisgarh. Paragraph 18 and 22.
Chhattisgarh not given. We have given Gujarat.
22 is remanding part of Birsha Kumari.
22 is three under, there is, the remanding can be done under 391.
Yes.
That is also given in Supreme Court judgments.
Hmm,
That is there.
that is there,
That is
yes.
not an issue.
Then Gujarat judgment, Lordship will find that page, paragraph 15. Retrial. FSL report was not exhibited. FSL report of the drugs, it's an NDPS case. The report was not, so retrial again. Paragraph 15 and 12. 12 Jahira case was referred in order to bring home the point that it is the duty of the PP to present all the documents before the court during the trial. That is why Jahira case was referred in paragraph 12 and paragraph 15. It was again retrial referred.
Habibullah Sheikh, okay.
No, Jahira Habibullah Sheikh. This is at paragraph 12. And Chhattisgarh's sanction order under the Arms Act was not exhibited. Here it was not sent for retrial. Here the conviction under the Arms Act was set aside.
You see, out here, you see, in Habibullah, says there, I do not know if it basically says that full and material facts are brought on record. Full and material facts, does it have to be by way of exhibiting document? Or that he has got to bring on record in evidence whatever he has come upon, by stating. I don't think there's a categorical assertion or, or decision made in
Or exhibition.
in the Supreme Court judgment that it should be exhibited. I don't think that is there. I think that is this might.
But here it is not exhibited. That is why it was sent back. Paragraph 15.
Okay. Then in that paragraph
15. Duty of the trial court to appreciate.
where does it say that not has not been?
No endeavor was made to bring on record what was the reason of the not you will see. No, this is what the first sentence does in the present case. We find that prime and pious duty of the trial court to appreciate the evidence for search of truth is abandoned by not exhibiting the FSL. This is what they meant. However, in hurry of disposal of the case by perfunctory and disregarding attitude of the evidence which is on record of forensic science laboratory and important evidence of investigating officer was hurriedly dispensed with for no reasons at all on record. Exhibiting was there.
Where does it say?
Lordship will see paragraph 13 last paragraph 13 last lines. Last lines. As stated herein above, not only the additional session judge has failed to exercise powers under 311, but even has not bothered to exhibit relevant documentary evidence which were already on record, which if exhibited would have been fatal to the evidence. Even FSL report, considering the provisions of CRPC, was straight away required to be exhibited. The learned session judge ought to have appreciated.
Considering which provision of the CRPC?
Exhibiting documents is not provided in the CRPC, but no, David, Evidence Act. Documents has to be exhibited. I think 311 is not the power.
Re-11 is re-examining
Ah.
witnesses. That is a different issue.
Exhibiting of any evidence of the action.
They are asking Mr. Google.
It's no Manupatra.
Lordship, section 59, 60, 61. Contents of documents,
Huh?
evidence that. Proof
Se-
of contents
section?
of documents,
Section,
61. 59, 60, 61. 59 is proof of,
just a minute. Section,
59. Proof of facts by oral evidence, then documentary evidence, proof of contents of documents. The contents of document may be proved either by primary or by secondary evidence.
Exhibiting.
Primary evidence is, means the document itself produced for the inspection of the court. When a document is executed in several parts.
that much
each
we
part-
know.
Yes.
So?
So it has to be. FIR, then postmortem report.
But supposing the facts are not disputed, then what happens?
Immediate fact need not be proven.
Then
Facts
is it
admitted,
required
not
to, is it required to exhibit the documents if the facts are not
So
disputed?
your lordship, if the witness contradicts to that point, then your lordship.
No, but then their case is that unless the documents are exhibited, we have no chance to contradict the witness.
Actually, if the documents are not exhibited, the documents doesn't stand proved.
Document doesn't stand proof, but then if the facts are proved by the witness, then what happens? Take for example, two eyewitnesses see one person A shooting B dead in front of their eyes. And all the FIR, all those documents are not exhibited. But if it is seen by them in front of their eyes that he died because of the shooting and he died in front of them, then what happens? Can we say that the offense is not proved?
Lordship, if they contradict, we have not seen the occurrence, we have not lost the FIR, then your lordship. And if they stand on its own footing in a cross-examination, that yes, we have seen the occurrence. Or maker of the FIR, we have lost the FIR, your lordship, then your lordship.
So,
If,
so let us be clear about what we want to, what judgment we are supposed to make. Let us be clear about the law, like,
lordship,
Other-
on the Friday, your lordship will, or I mean.
you understand what I'm saying?
My lord,
Because if there is in front of us, we see everything.
yes.
But FIR is not exhibited, PME is not exhibited, charge sheet is not exhibited, nothing is exhibited. But it is there. And the facts are proven by an eyewitness. Say around 100 eyewitnesses also, or not even 100, but 2 is enough, not the number. Then can we say that just because documents not exhibited, that offense is not proved?
That aspect, Lordship had said that if there are eyewitnesses, but then there are no documents, whether it can be believed. Lordship can see paragraph 13 of the same judgment. Because here also that situation was analyzed.
Page 13.
Paragraph 13,
In which
lack
case?
of robust judging.
In which case?
In this Gujarat, I think. Gujarat.
Gujarat.
Yes. A lack of robust judging.
Ah.
Lack of robust judging has stated in criminal courts need of the hour is robust judging. The trial judge is the linchpin in every case. And he has only its eyes and ears. He is not merely a recorder of facts, but a purveyor of all evidence, oral and circumstantial. It is said by him that a good judge needs to have a third eye, that is, hear and comprehend what is not said. When a material eyewitness whose beloved relative has been murdered and who has identified the accused in his police statement says in her evidence at the trial that he cannot recall the faces or names of anyone, this must obviously excite suspicion in the mind of truth-seeking judge. Then Lordship will see this, he has analyzed, thereafter said that documents also needs to be seen. Then no
No,
new.
but out here, you see,
Ah,
it is,
only having a found
he
it.
cannot recall the faces or names of it.
Ah,
Yes,
this,
okay, so this is different.
this is, he
This
could
is
not.
slightly different. You see, when he has identified the accused
Ah,
in his police statement,
mm,
but at the time of trial, he says a different thing. He
Uh-huh.
says that he cannot recall
Recall.
the faces or names of anyone. That means he cannot identify the accused at the time of
that
trial.
was.
That is a different issue. What the question was put
Mm.
was that the accused, the witnesses have identified the
Uh-huh.
accused and they identified the fact that he had shot him
Mm,
and that that person died in
mm,
front of them. What more is required?
mm. No, in presence of them,
Can-
nothing will be required. It is also a little bizarre to say because, okay, PM report may not be there. Even the corpus
so-
delicti
so-
may not be there.
So the
But
question is a contradiction required to be proven first
Mm,
before saying that, the documents have to be exhibited.
yeah.
Meaning to say, if the, if there is no contradiction, is there any requirement of having documents to be exhibited?
Mm. No. That is a, I have not seen that whether. But normally we are under the impression needs to be exhibited. Yeah, I've got one decision where it is said 161 also needs to be exhibited. Supreme Court. So, but we knew that, but this is of course a very valid question. If eyewitnesses are there, things are very apparent, then whether,
Hostile is this. 160 will be executed in case of hostile.
Yes.
but yes, but I'll bring that judgment whenever.
No,
it
this
is-
is, now, the basic thing is this.
Ah,
If there is no contradiction
mm,
of the witnesses,
mm.
can an offense be said to be not proved
Yeah,
just because some procedure was not followed?
ah. Cannot be.
Huh?
I'm yet to find the decision on that, but yes, in common sense, what we can say, it need not be.
That is the issue.
Need not. Requirement is that ocular evidence to prove a case.
Ah,
It doesn't say we need also documentary apart from that. That Chhattisgarh decision, Lordship will see, this is on sanction order.
Ah.
This is of course, the case was not sent for retrial. The Arms Act provision was set aside. This is Arjun Thapa. This is paragraph 20, 19 and 21. 19, they refer to another decision. Lordship will see there, Andhra Pradesh decision was referred. The Andhra Pradesh High Court dealing with section 39 of the Arms Act has held that sanction as contemplated under 39 of the Arms Act is not an empty formality and it is introduced to safeguard the persons against any prosecution. When once a sanction order is issued by the district magistrate, somebody on behalf of the department shall come before the court and mark the same as an exhibit. And where the document, though available on record, has not been marked as an exhibit, the same cannot therefore be used as evidence. Although it is there but not marked, cannot be used as an evidence. It is.
no, but then isn't it enough to convict a person on the evidence of the eyewitness?
That of course, that slice.
That is with regard to convicting a person on the basis of document. You can convict them on the basis of document or on the basis of ocular evidence. But which is of more important?
Ocular will definitely.
Ocular evidence is more important, I think.
Perhaps in Mizoram case, there were no eyewitnesses. I did not see. Mizoram case. There were confessional statements.
Because it's very easy to take the, one thing is that Uh, uh,
Hmm.
the safest route, no doubt, is have another, remand it and do it again, no doubt.
Hmm.
And probably it'll come to the same thing. But the question still exists as to whether uh, ocular evidence is enough to convict a person or
In Mizoram case, there were ocular evidence also. Still then it was.
no, but that aside. We don't have to follow blindly everything that is in front of us.
Hmm.
We've got to question.
Mhm.
That is the way the law will,
Develop,
grow
yes.
and develop.
Ah.
Lordship, maybe taken up on Friday. then.
Yeah.
Friday.
It's private. We should make a guideline, ne? To the law court district court. The federal government should take decision to the remand of that. And they have not raised the trial for all. See.
On Friday, Lord.
Make physiological. If this appeal is directed against the impugned judgment and order dated 22/12/2017,
Yes,
passed by the Leonid Session Judge Ipu Kabiangler, whereby the petitioner has been sentenced to rigorous imprisonment for life under section 302 IPC. I have gone through the records, Your Lordship. What I found is that the Learned Trial Code here
yes,
has reversed this golden principle that the prosecution must prove its case. Rather, the Learned Trial Court was of the view that the defense has failed to prove his innocence and therefore the conviction was granted.
yes.
Now, the allegation is that he has killed his
Put this
wife,
in
Your
the
Lordship. Main allegation is that he has killed his wife.
Yes,
The FIR is at page number 4, which leads to the initiation of the criminal case at page 4, Your Lordship.
FIR lodged by whom?
By the mother of the deceased,
PW,
PW3,
mother of deceased,
mother of the deceased.
mother of deceased. And who is the accused? He is the appellant,
Husband of the deceased.
husband of deceased.
Deceased. This is a jail appeal, Your Lordship.
Jail appeal.
Jail appeal.
And how old is the appellant?
The appellant at present, he will be about I think 40, 44, 42,
And the
43.
deceased was how old when she died? huh?
At the time of incident, it is alleged that she was 21 years old,
21.
21,
How long had she been married?
3 years.
more than 3 years. They have also children.
Okay, let us go to the FIR.
Lordship, that is at page number 4 of the paper book.
FIR dated
FIR dated 21/6/2010. 21/6/2000.
23.
It's the very day of the occurrence, date of occurrence.
So that time he was how old?
It will be about 20, 24, I think.
So he is still in jail? No, he is.
He's still in jail, about 6 years.
Yes,
Lordship, may I read that? To the officer in charge, the humble submission is that at around 10 AM today, that is on 21/6/2000, Atabur Rahman alias Salim, the son of late so-and-so, residents of Panbari under Difu police station, assaulted his wife, Kamala Begum, the deceased, who is my daughter from my first husband, late so-and-so, to death inside the house itself and fled the scene thereafter. So the FIR is very cryptic that he has assaulted, which led to the death of the deceased, Your Lordship. Now, Lordship, in order to prove this case, the prosecution has relied on 5 witnesses, Your Lordship. Initially, the case charge was framed by the learned judicial magistrate, and then it was committed to the Court of Session since charge was framed under section 302 IPC, Your Lordship. Now, start with the depositions, Your Lordship, which led to the conviction on the instant case. A PW1, Lordship, will get it at page number 9.
yes,
He is one Bimal Rai, he is not an eyewitness, and even he did not visit the place of occurrence also. He is basically a signatory to the inquest report. May I read your lordship?
Yes.
PW1. I know the accused person on the dock. I knew his wife, Kamala Begum also, who is now dead. I came to know that wife of the accused was murdered. He came to know it. I came to know while there was Halla Gulla at about 9 a.m. and the police came there. Police people asked me about the fact. I did not tell them anything regarding death of the Kamala Begum. The house of the accused is situated nearly 100 yards away from my tea stall. So he was in his tea stall. He heard some Halla Gulla. He did not see the incident. The police. And then across your lordship, he said that at the next page, it is not a fact that I had gone to the place of occurrence. That is, he did not visit the place of occurrence. Police obtained my thumb impression in front of my tea stall after completion of inquest. So his signature was taken by the police after completing the inquest in front of his tea stall, which is situated about 100 yards away from the place of occurrence. He neither saw the incident, he neither visited the place of occurrence. It is only that he has put a signature after the police asked him to do so in the inquest report. That is his version, your lordship. He is a tea stall vendor and basically a hearsay evidence. He did not know anything about as to how the disease was killed.
Yes.
PW2, your lordship, will get at page number 11. He's one Sri Natuni Shah. He is also basically a signatory to the inquest report. He also did not see the incident. May I read the examination chief, your lordship? I know the accused person on the dock. I knew that the accused has been staying in the rented house of Chotu Shah along with his wife since expired. I have the knowledge that the wife of Atibur Rahman was expired few years ago. I do not know how did the woman die. Police came to the spot and obtained my signature on the inquest report at the tea stall of Bimal Rai. That is the tea stall of PW1. He was also there. So police came and took his signature from there in the inquest report. I did not see the dead body. On the day of occurrence, I came out of my house for sale of vegetables in the market and coming back at about 9 a.m. So he was a vegetable vendor basically. And in his cross, he stated that I had not stated anything before the police. So he has also did not see the incident. He also did not visit the place of occurrence. The police took his signature on the inquest report in the tea stall of the PW1, where he was there, your lordship. So this is PW2, your lordship. PW3 is the informant, your lordship, the mother of the deceased. PW1 was a tea stall vendor and PW2 was a vegetable vendor. Both of them were signatory in the inquest report. Their version is that they did not see the incident, they did not visit the place of occurrence, but the police had taken their signature in the tea stall of PW1 in the inquest report. The evidence of PW3 is at page number 13, your lordship. She is the informant of the case. May I read, your lordship? I know the accused person on the dock. My daughter Kamla was married to him. Kamla is since dead. About 4 years back, while I was not at home, I got the information from Hasina that my daughter Kamla had been killed. So this is important, your lordship. She got the information from one Hasina who told her that her daughter has died. So Hasina is a vital link from whom she has come to know that the disease was being killed by her husband. I was also informed by Hasina Begum that Atibur Rahman, husband of Kamala, had killed her. So she again mentioned it was Hasina Begum who had informed her that the husband had killed her daughter. Then I had rushed to the place of PO at Panbari, about half kilometer away from my house. I found that my daughter was lying dead on the bed. I started crying. Police who were in patrol duty came to the spot hearing the cry. I saw the dead body only. I saw no other sign on the dead body. So did not notice any other marks on the dead body. Police had started inquiry and prepared the inquest report in my presence.
Mr. Islam. Mr. B. Islam. For the single bench you have come. That will be at 2 o'clock. Okay. For that preferential, for that case of yours, preferential appointment. I know. Now you have got a medical certificate. At 2 o'clock. Yes, yes, so
I was reading the deposition of PW3, Your Lordship.
Hasina Begum not made a witness,
Hasina Begum, the prime link that she had told her.
not
that her-
made a witness.
Not made a witness.
Who is she? We don't know.
Who is she also? That also we don't know, Your Lordship. So only these 3 witnesses they have. One is the vegetable vendor who was not a witness to the incident. One is the pistol vendor and other is
Then
the
what else?
PW3, Your Lordship. May I read or let me complete, Your Lordship. And I put my signature on the inquest report. I had submitted a FIR before the police written by one Mintu Datta of Sitalabari. So she did not write the FIR. The thumb impression on the FIR is mine. Police had seized some articles like pieces of sari, etc. I had put my thumb impression on the seizure list. The dead body after 9 p.m. examination had been handed over to me. My daughter was married to the accused before 3 years of her death. The accused had the habit of torturing my daughter off and on, and also tortured before the day of incident. I could see the accused at home while I visited the place of occurrence. So it is her version that when she visited the place of occurrence, she found the accused at home, Your Lordship. It is not that he had fled away or that something like that. After about 1 month, he was arrested by the police on my information. I have not seen the occurrence and therefore I cannot say anything on the incident. So 2 things are there. One is that she had got the information that the husband of her daughter has killed her. That also from one Hasina who has not been examined. And that she did not notice any sign, any other sign in the dead body. And further that she found the accused on the place of occurrence when she went there, Your Lordship.
Then
Cross, Your Lordship, while I got the information about the incident from Hasina, I was busy in marketing near roadside outside my house. While I visited the area, my sister Saida accompanied me. Her sister Saida had also accompanied her, but she has also not been examined. Police came to the spot hearing my cry and I filed the FIR on the spot. The seized articles are not produced before me. Then, Your Lordship, one BTP secretary was examined. He also stated that he did not see the incident. Only he could come to know from the local people. May I read, Your Lordship? I do not know the accused person on the dock. PW4, Your Lordship, at page 15. Only on the
Yes.
day of arrest, I could know him. I know Srimati Asia Begum, the complainant of the case. So he was known to the complainant. During the period of occurrence of the incident, I was BTP secretary of Panbari village. On the day of occurrence, police people called me to the place of occurrence and told me that the wife of the accused was found dead. So he was called by the police. It was about 9 p.m. I had put my signature on the inquest report as witness. Later on, I came to learn from local people that the husband of the deceased woman had killed her. So this is, he got the information later on at the instance of the
Yes,
police he
yes.
visited, Your Lordship. Then PW5 is basically the IO of the case, Your Lordship. And PW6 is the doctor who has examined or done the post-mortem, Your Lordship. Now PW5, Your Lordship, police, the IO of the case, Your Lordship. In his cross, he had stated that I had visited the place of occurrence at about 1:30 p.m. after investigation of the case. I found no eyewitness there on the spot. I examined the complainant Aisha Begum, PW3, Hasina Begum, Hussain Ahmed, Bimal Roy, Sumitra Devi, Natunani Shah, and Nurul Islam. So he said that he had examined Hasina Begum, but she was not produced, and we don't know whether there is any evidence of her in section 16190. Then one Hussain Ahmed, one Sumitra Devi, the person whom he had examined, he did not make them prosecution witness to depose before the honorable court, your lordship. All the persons who had deposed, they were neither eyewitnesses, not they had even visited the place of occurrence also. It is at the instance of the police, they had only put the signature on the inquest report that was being produced, that was being prepared by the police. your
Yeah,
lordship.
then
And then the last one is the deposition of the doctor who had conducted the post-mortem, your lordship. On 21/6/2000, I was serving as SDM and HO at Diffu Civil Hospital. On that day, that body of so-and-so was escorted by Constable so-and-so. Postmortem exam was conducted by me at 4:10 PM on that same day. I found the following in the dead body of the female of about 21 years. One is a semilunar injury mark near the right upper front of the neck, with nail-like light impression and multiple blackish colors over the front of the neck with local edema. And secondly, on cut section of the blackish coloration of blood coming out from the surrounding area of the neck, antemortem in nature. In my opinion, death is due to asphyxia as a result of throttling. So this is the post-mortem report which is suggesting
so
throttling. That is the opinion of the medical, your lordship.
313 statement,
Lordship,
313.
313 at page number 21, your lordship. The relevant question, I think it is question number 5, your lordship, to which he has answered. I cannot say anything as at that time I was not in the house. Prior to the occurrence, I found the deceased wife sleeping with another man. And thereafter, I went to the house of my mother-in-law saying that I would not further keep the deceased as my wife. Coming home back, I found the deceased hanging. Thereafter, I took down her from hanging for nursing her in presence of my landlord, but she died during nursing her.
So you found her sleeping with another man?
That is the statement he has given under section 313, your lordship.
Yeah, so you found her sleeping with another man, then you went to your in-laws house and told her that you would not be keeping your wife as your wife any longer.
Lordship.
Then coming back, you found that the deceased was committed suicide by hanging herself.
Lordship.
There, I took her down for nursing in presence, but she died during nursing. So, according to you, she was still alive when you took her down, but
No.
she died while you nursed her.
That is not your lordship.
Hmm?
I thereafter took on for nursing her in presence of my landlord, but she died during nursing.
Then she died during nursing. She did not die due to hanging. She died during nursing.
And in presence of the landlord, your lordship.
Whatever.
Now, this
Now,
is
you see, that is one aspect. So, according to you, there is no evidence against you.
the lordship. And the prosecution has miserably failed to prove any link, your lordship.
Now, just answer one question. When were you arrested?
I was arrested after about 2 months, your lordship.
2 months. What were you doing? Your wife is dead. You nursed her, and she died while you were nursing her. Then you disappear for 2 months. What, you were mourning secretly or something?
There was an affair by the mother of the deceased.
So you ran away.
That may be the conduct, that may be the reason, your lordship. That may be the reason for, because they are people from the villages, and at that time he was 24 years old. Out of fear, he might have run that if you go inside once, you will not be able to come back, your lordship.
We cannot go by what he might have felt, because that is just presupposition. The fact remains that you went missing for 2 months. How many children did you have with her?
Got somewhere that one child, I think.
One child. And what did you do? You took the child with you also for the 2 months. You have to explain those 2 months. What happened? Your wife dies and you run away because you are scared that you will be falsely implicated.
The PW3, when she visited the place of occurrence, he was there. She has stated that when she visited the place of occurrence, the accused was there on the spot. If your lordship kindly takes up the deposition of PW3,
So is she correct or wrong?
I could see the accused at home while I visited the place of occurrence.
So
After lodging of the affair, I think he might have. At page number 14, your lordship will see.
So if you were there when your mother-in-law came, why didn't you go to the police, both of you, and said that my wife died? Why did you run away? Is that the normal reaction of an innocent man?
No, because at that time, by that time, her mother-in-law has already implicated him, your lordship, directly.
No, no, no.
At the place of occurrence, she has lost the FIR, your lordship, because police came and then she lost the FIR.
Then
This might be the reason for which he had escaped, your lordship. Because once in a FIR is lodged, generally every accused, he goes and try to get some anticipatory bail, but thereafter, after two months, your lordship, he has been behind the bar after 2 months. Tender young age, your lordship, and once FIR is lodged by the mother-in-law saying that my daughter's husband had killed her, definitely, your lordship, as a general, that would happen, your lordship, who will flee away, your lordship.
will it?
Well,
Will it? Supposing we have a poll. Supposing we have an opinion poll amongst all the lawyers here. And we ask them that forget your wife, say your close relative somewhere has say passed away in your presence. And their mother, the deceased mother or something, files a FIR. Say against the lawyers here who are there. Will they run away? Would it be the normal reaction of a man? Do you think that would be the normal reaction of a man? They'll say, no, I did not do it. That's all. What would happen? Now why don't you consider yourself in that place of that husband?
as a lawyer, your lordship, we know.
No, not as a lawyer.
But
I'm asking as a normal
he's a-
prudent man. He's not a lawyer.
He's
Remember,
a
he's
village man, your lordship,
he's a village
tender age of 20 to 24 years old.
so why should he run away if he's innocent?
He was there at the place of occurrence when his mother-in-law visited, your lordship.
Now take me as a judge. Supposing a similar thing happened, touch wood. Would it be normal if I run away?
Because many times you find they run away and then they come before through the advocate.
After 2 months?
No, through advocate for filing anticipatory bail application. These things also happen, your lordship. We are experiencing after murder,
After 2 months.
not of,
And out here, he did not surrender, by the way. He was arrested.
that is not very clear, but whether he was surrendered or not, but after 2 months.
On my information, PW3 said.
Hmm.
On my, after 1 month, it was arrested on my information.
That she has informed about him and then he was arrested.
Anyway, so that is the basic case. The basic case is that no evidence to prove that the offense was committed by him
Lordship.
because there were no eyewitnesses, all hearsay. The only thing that is against you is the fact that you were there.
Section 300.
You were there at the time she died. At the time she was dead, you were there. And then you disappeared for 2 months. Because PW3 has seen you when she came to the house. But after that, you could not be arrested. And if you had not run away, you might never have been arrested also, we don't know. Anyway, that's a different issue now. So that is the basic case. I think.
Basic, the basic. It is the prosecution which must stand on its own footing. They cannot rely on only under section 313 CRPC. If they had said that yes, the Hasina Bibi who had informed her that this person has killed, some link would have been created that yes, that person had killed. Nothing, absolutely nothing from the prosecuting witness, and the vital witnesses has not been examined.
Okay, we'll just rise for 2 minutes.
Lordship. এই 313 to না দিলে এখন আছে।
Evidence more.
এখন না এভিডেন্স দিব খালি ইনকোয়েস্ট রিপোর্টের দিকেটা তাক এভিডেন্স দিতে হবে তাহলে এভিডেন্স এখন আর ইনফরমেন্ট দিব এই তিনজন নরমাল দে আর অল সিগনেচারি টু দ্য ইনকোয়েস্ট In this case, your lordship, what we have found is that there is not a single witness.
Correct.
Not a single witness
Correct.
except the informant.
Correct.
And in the-
Informant is also not a witness.
not a witness.
Only she has witnessed your presence in the
Present.
house.
After-
And that is not disputed also.
that is not disputed also.
You were there in the house.
He was there in the house.
So you were there in the house at the time she died.
Might be your lordship.
As per your 313,
313 statement. I have,
as per her evidence, you were there when she was dead.
it is a
that
translated one, your lordship. I
as a-
don't know the exact, whether it conveyed the exact meaning or not.
But
This one I think is translated.
Which one? Which one?
This 313 statement or it is,
Acha, let us see that. Yes, let us see that. Correct. Let us see that.
we don't know.
Yes.
There something happens.
No, but the fact remains.
Yes,
Is that at the time she was dead. We do not know she was alive, but at the time she was dead, you were there.
he was there. He was there. Even the mother-in-law went there and found him there. Thereafter, she had lost the affair.
Thereafter, you felt guilty that thereafter you were scared, according to you.
Lordship.
You were scared.
Scared.
And that's why you,
And for the first 2 months, even the police might not have arrested because they might also, I don't know, for the first 2 months, why the police did not make an arrest. It may also be there that the police initially made some investigation and thereafter they arrested him. That is also not come that immediately whether the police, he ran away after seeing the police or something like that. We don't know, your lordship.
It's in English one.
It's an.
okay,
So what is only 313 CRPC where some indication is there. Otherwise, your lordship, from the prosecution side, your lordship, not a single, the main witnesses whom we can say that one Hasina Bibi who had informed that informant that your daughter has been killed by that man, she has not been examined. The landlord of the house where the incident occurred, your lordship, he has not been examined. So the prosecution completely failed to prove out any case against the petitioner.
No evidence.
No evidence. And the court, learned court below, relying on section 106, your lordship, has convicted the accused appellant. Although the learned court below was also of the view that the prosecution could not substantiate by producing relying and cogent evidence, your lordship. So the impugned order starts at page number 25, your lordship.
Yes.
And paragraph 14, it is a long paragraph 13, your lordship,
Yes,
at page 28.
yes.
There is no any direct evidence which shows that the accused committed murder of the deceased. There is no dispute that the dead body was found in the house of the accused was her husband. The defense has not totally disputed contents of the inquest report and postmortem report. That is, the disease has not totally disputed. The court has gone in that direction. That disease. There is no evidence on record showing that anybody saw the dead body in hanging condition. It is pertinent to mention that the prosecution could not examine vital witnesses, namely Hasina Begum and Hassan Ahmed, because they went untraced during the trial of the case. That is the person who are there and why they have not been examined, your lordship. And then the court relied on various judgments subsequently, your lordship.
Paragraph 16 court's conduct.
Hmm?
Paragraph 16 conduct of the.
Conduct of the post conduct of the.
What is this section 8 that court is talking?
Evidence conduct.
Anything else? That's all.
That is there, and your lordship. There are judgments of the honorable court, and your lordship also knows that the first burden lies on the prosecution. Once the prosecution discharges its duty, then the burden may shift to a certain extent. In that regard, your lordship, I would like to want to judgment of the honorable effect for your lordship.
You give both the judgments at one time. That is
Lordship.
fine.
The first one is 1956 AIRSC 404, which is still holding the field, your lordship. Shambhunath Mehra versus State of Ajmer.
Yeah.
Paragraph 10, your lordship, page number 3. Where the court says, section 106 is an exception to section 101. Section 101 lays down the general rule about the burden of proof. Whoever desires any court to give judgment as to any legal right or liability, dependent on the existence of facts which he asserts, must prove that those facts exist. Illustration A says, A desire a court to give judgment that B shall be punished for a crime which A says B has committed. So A must prove that B has committed the crime. This lays down the general rule that in a criminal case, the burden of proof is on the prosecution, and section 106 is certainly not intended to relieve it of that duty. On the contrary, it is designed to meet certain exceptional cases in which it would be impossible or any rate disproportionately difficult for the prosecution to establish facts which are especially within the knowledge of the accused and which he could prove without difficulty or inconvenience. The word specially stresses that it means facts that are predominantly or exceptionally within his knowledge. If the section were to be interpreted otherwise, it would lead to a very startling conclusion that in a murder case, the burden lies on the accused to prove that he did not commit the murder, because who could know better than he whether he did or did not. So the first burden, that is proof beyond reasonable doubt, that is not being dispensed with. Once the prosecution establishes a case beyond reasonable doubt, then your lordship, the burden may shift to the other side to prove that in fact he has not done it. So this is a case where the first burden, that lies with the prosecution, they have miserably failed to discharge it, your lordship. And second case also, your lordship, recent case, relying on this case, the Honorable Apex Court has said that the burden can never be shifted, your lordship. Then the prosecution must prove its case, and thereafter, your lordship, if certain occasions arise, the defense may be asked as to why he had done it or done that, your lordship. So, your lordship, this is a case where absolutely the prosecution did not attempt, or in fact, they have not made the prime witnesses make their deposition before the court. The person from whom the informant received the information that her husband had killed her, they have not been, even the
Okay,
landlord
this-
has not
in
been
this-
examined.
In this other case, the second case,
Lordship.
what Farah?
Lordship. This is sector thing. This is also the husband was alleged of murdering his wife, your lordship. Lordship. From 10, 11 and 10 and 11, your lordship. In section 10, the court has said that the IO has miserably failed to
Sharad Birdi Chand Sada, okay. Same.
say, your lordship, that this is the initial burden which has to be satisfied by the prosecution, and then the lordship, the case goes otherwise. And if your lordship thinks that your lordship, that he has in fact committed such heinous crime, then I think that in such situation, your lordship, it may come under exception 1 to section 300, your lordship. This is my second limb of argument. If your lordship does not find that
What comes out, section,
exception 1 to section 300, your lordship.
exception 1 to 300.
Grievance, he found his wife to be in a compromising position with another man, your lordship. It is nowhere it is being stated that he had any difficulty or he had any strange
Exception
relation.
1 to section 300.
So I'll not go to that because my case is on that, your lordship. The prosecution has failed to prove out a case, your lordship. Nothing, your lordship, the prosecution has shown. So only relying on section 313 or section 106 evidence act, the burden cannot be shifted to the other side, your lordship. So this is my case, your lordship.
Yes, but
Karthik knows that Trimukh Maruti case where it is said.
that 106.
No, not only 106, I'm relying on another paragraph where it is said that when the murder is committed within the
4 walls.
four walls, then the kind of circumstances may be little lesser than what is required
Yes,
under the law.
Yes.
So here the circumstances, because the case rests on circumstances. So circumstances that I can call out is first they were together in the house. Children, I have not found anywhere whether there is any son or daughter.
There is nothing mentioned.
I
I
subject
think
to correction.
I-
And they were there inside the house and the incident took place at around 9 AM in the morning. And there was a hue and cry. And there was a hue and cry and police personnel who were on patrol duty, they reached the place of occurrence. And then mother was informed. Mother reached. And mother saw the body lying on the wooden bed. And mother also said that accused was there. Mother said accused was there. And then the mother also said there was torture. He used to torture her off and on. And on the day of occurrence also there was a torture.
That has not been denied.
That has not been denied. So this stands. So day of the torture, day of the incident, there was a torture. Then no valid explanation as required under 106. How did she die? 106. I'm simply saying I saw him with another man. I went to inform my mother-in-law. And mother-in-law did not say that my son-in-law had come and informed me or whatever. He had come, not informing, she will not say.
It was
But-
informed by somebody else.
She was informed by Hasina. So she came. So she had no knowledge. So his explanation in 106 says that it was an incorrect statement. An incorrect statement becomes a link in the circumstances.
What
Additionally,
incorrect statement?
the accused statement under 313 seems to be an incorrect statement and it becomes a link in the circumstance. So no valid explanation. And then
Any citation to that effect?
incorrect statement, they don't have, but incorrect statement makes a link to the circumstances that I had. I'll give it during the day when lordship dictates, I'll give it. Then the conduct, His conduct under section 8 immediately after 21
But
5,
where is it stated that he absconded?
he was not found. This is what police said.
Where?
Police in his statement said, Roche will see page 18, accused was not found on the spot. Was on the spot,
No.
just said. Accused was not found on the spot. He was arrested on 24/8.
Okay.
And mother said that accused got arrested on my information. After 1 month. This is little wrong. After more than 2 months rather. And the death was due to throttling. Lordship got it, that part.
Yeah,
Yes, and Lordship will also see the mother saying that on the day of torture also there was, on the day of incident, there was torture in page number 14.
record.
And of course, and death is by throttling. There were nail marks and all.
That's it, yes, yeah.
Lordship. About that arrest part perhaps. No?
What my friend is suggesting that it was because of torture, that she was tortured by the husband. But if the lordship takes up the statement of the PW3, I saw the dead body only. I saw no other sign in the body. There is absolutely no other if there is any torture, there must be some sign, and then lordship that will have happened. So there is no other sign in the body, and the postmortem report also says that there is no other sign in the body.
More than that, it's, more than that, it says here,
No, inquest report. there are
the accused had the habit of torturing
a
my
habit
daughter,
of torturing.
That
off and on. Not on that date, maybe, but then you had a habit of torturing
Not,
your
has
wife.
not been proved, your lordship.
But
No,
inquest-
which has not been, you have not confronted the witness saying that this is false.
And moreover, in the inquest report, Lordship will see there are injuries. Page number 39.
Postmortem report done on the same very day, your lordship.
But in inquest, second paragraph,
So far
there
as
is a
injury, your lordship,
scar
there is
on the
nothing.
left side of the forehead, above the eye. Eyes are closed, mouth is slightly open. Near the throat, there is abrasion in the right side, below the chin. A blackish mark is seen on the neck. Neck is okay. Hands are lying parallel, hands are and so and so.
Inquest report, page 39.
Hmm. Backside, there are no injuries, but the second paragraph, middle portion. There is scar on the left side of the forehead, above the eye. Near the throat, there is an abrasion in the right side, below the chin. And blackish mark on neck. Neck is due to throttling.
So you have been in jail for 6 years.
6 years.
It is given in the constitution.
Oh, yes.
It may be more also. Since conviction, it is almost about
5 years, 7 months. Converting will not be possible because there is no element of any provocation, right?
Except his 313.
Except history one.
That means he's admitting.
Hmm.
So you
you cannot be
cannot
taken
give-
recourse to your lordship when the prosecution could not make out a case, your lordship.
So you are not pressing for the exception to 300.
Then otherwise. If it is also case of.
Okay, right.
Secondly, your lordship, if it is- otherwise it is a court of throttling also, then the fingerprints ought to have been collected, your lordship.
Where is it?
No, that is very vital evidence, your
How
lordship.
do you, I've not heard of collecting fingerprints from skin, from a neck. How do you do that? Have you ever heard of it? Have you read somewhere? That fingerprints will remain on your, on the skin. From where have you read that?
That may not be good.
Huh? You please enlighten us. We want to know this new development. Right. Heard Mr.
MH Last.
M.H. Das.
Laskar.
M.H. Dastar, Current Councillor Amicus Spirit, and Ms. L. Jahan, additional people. This appeal has been preferred against the impugned judgment dated 20/12/2017, passed by the court of the, judgment dated 20/12/2017. Slash 22/12/2017. Passed by the Sessions Judge Karbiang Law, Difu, in Sessions Case number 25/2002, by which the appellant was convicted under Section 302 IPC for killing his wife and was sentenced to undergo a rigorous imprisonment for life with a fine of rupees 2,000, in default, simple imprisonment for 6 months. The prosecution case in brief. That's all. Twenty-four or 25 or 24? Okay, whatever, first up, the prosecution case in brief is that an FIR dated 21/6/2000 was submitted by PW3 by prosecution witness 3 bracket PW3, who is the mother of the deceased, which is to the effect that the appellant, who was her son-in-law, had assaulted the deceased at 10 a.m. on 21/6/2000. Leading to her death inside their house, and thereafter had fled the scene of crime. Pursuant to the FIR submitted by PW3, DFU PS case number 102/2000 dated 21/6/2000 was registered under section 302 IPC. Next paragraph. The IO thereafter, the IO bracket PW5 thereafter started the investigation of the case and visited the place of the crime on 21/6/2000 itself. However, he could not find the appellant, who was subsequently arrested only on 24/8/2000, that is 2 months after the deceased had been killed. After completion of an investigation, the IO submitted the charge sheet, having found a prima facie case under section 302 IPC against the appellant. Thereafter, the learned trial court examined 6 prosecution witnesses. The appellant was thereafter, the appellant was also examined under section 313 CRPC. Wherein he denied having any involvement in the death of the deceased. However, with regard to question number 5, the appellant in his answer under section 313 CRPC stated that he was not in the house at the time the IO had gone into the house. Had come into the house. He first, the appellant further stated in his answer that prior to the occurrence, we make it in inverted commas, prior to the occurrence, I found the deceased wife sleeping with another man. And thereafter, I went to the house of my mother-in-law, saying that I wouldn't further keep the deceased as my wife. Full stop. Coming back, I found the deceased hanging. Full stop. Thereafter, I took down her from hanging for nursing her in presence of my landlord. Thereafter, I took down her from hanging for nursing her in presence of my landlord, but she died during nursing her. Full stop. Invert commas. Next paragraph. On considering the evidence adduced by the prosecution witnesses and keeping in view the answer given by the appellant in his examination under section 313 CRPC. The learned trial court came to a finding that the appellant, the answer of the appellant under section 313 CRPC suggested that he had murdered his wife, having found her in intolerable circumstances by strangulating her. The learned trial court also held that the past conduct of the appellant played a vital role, and that immediately after the occurrence of the crime, the accused had left the place of occurrence and absconded. Further, the appellant was arrested only after about 2 months from the date of occurrence. The learned trial court also held that under section 106 of the Evidence Act, the appellant was to explain as to how the deceased had died, as he was found to be inside his house with the dead body at the time of death of the deceased. The learned trial court thereafter held that the circumstantial evidence in the case along with the evidence recorded by prosecution witnesses 3, 4, and 5 prove that the appellant was the perpetrator of the crime in killing his wife by throttling. Accordingly, the appellant was convicted under section 302 IPC and sentenced accordingly. Imposed upon him. Next paragraph. The learned counsel for the appellant submits that none of the prosecution witnesses were eyewitnesses to the death of the deceased, and all the evidence was hearsay. The learned amicus curiae further submits that while PW3 had stated that she had heard about the death, she had heard that the appellant had killed the deceased from one Hasina Begum. However, Hasina Begum was never made a prosecution witness. He further submits that the case IO bracket PW5 in his evidence had mentioned various persons who had been examined by the IO for coming to a finding that sufficient materials were present for prosecuting the appellant under section 302. One of them being which person? Hussein Ahmed Yusuf.
Hasina Begum, Hussein Ahmed and Sumitra Devi.
Uh,
Hasina Begum,
Hasina Begum, no, one of them being Hussein Ahmed. Besides Hasina Begum and Sumitra Devi. However, the above persons were not made prosecution witness, thereby implying that the prosecution had something to hide from the court, from the learned trial. What is the next paragraph? The learned amicus curiae submit that the burden to prove a case against an accused lies firstly on the prosecution and thereafter thereafter the defense is asked as to what had happened. Then the defense is to be asked as to what had happened. However, in the present case, the prosecution has not been able to prove the foundational fact that the appellant had murdered his wife. They accordingly submit that in view of the above, the appellant should be acquitted of the charge framed against it, and consequently, the impugned judgment should be set aside. In support of his submission, the learned amicus curiae have relied upon the judgment of the Supreme Court in the case of Dash versus Dash, 1956 AIRSC 40. Next paragraph. The learned additional PP, on the other hand, something that though there were no eyewitnesses to the crime, the circumstantial evidence proved the guilt of the appellant in murdering his wife. She submits that the incorrect statement made by the appellant during his, while giving his answer to question number 5. During his examination under section 313 CRPC. Provides a link to the circumstances proving the guilt of the appellant.
And that actually is the last link. Lordship can see the judgment I've got. That Sarda, we see that decision on 5 golden principles. That Sarda case.
Which is Sanda.
Sarat, yes. There Lordship will see paragraph 159 and 60. When incorrect statements where it becomes an additional link. This is only as a last resort, but
First, it becomes the link, say it becomes the additional link. Becomes the
Additional.
additional. In this regard, she has relied upon the judgment of the Supreme Court in the case of so and so, reported in 1984, 4 SCC
116.
116. You read para 150, 859, huh?
159 and 60.
159, 60, 159, 60. Next para. The additional PP also submits that the very conduct of the appellant in absconding from the place of occurrence and having been arrested from 2 months after the death of his wife also proved the guilt of the appellant. She also submit that
Hue and cry and the torture also.
Huh?
Hue and cry and torture.
and she also submit that the evidence of PW3 to the effect that the appellant had a habit of torturing the deceased on and off, and that she had also been, and that the deceased had also been tortured before the day of the incident, has not been questioned by the appellant, has not been denied, or questioned by the appellant during cross-examination of PW3. Correct? That's all for the. We have heard. No, just said before that, accordingly subject that the impugned judgment of the learned trial court should be upheld by the court. We have heard the learned classes for the month. As stated earlier, there were 6 prosecution witnesses who were examined by the learned trial. There are no eyewitnesses to the crime. However, PW3, who is the mother of the deceased, had stated in her evidence that when she got the information from one Hasina Begum that the appellant had killed her daughter, bracket wife, she had gone to the house, to her daughter's house, and found her lying dead on the bed. A police patrol party who were on duty came to the spot on hearing her cry and started inquiry and prepared the inquest report in her presence. She submitted an FIR before the police written by one Mintu Datta of Sitallabari. Police seized some articles like pieces of sari, etc. Wherein PW3 put her signature on the seizure list. PW3 in her evidence also stated that the dead body of the deceased was handed over to her after post-mortem examination. She also stated that her daughter was married to the appellant 3 years before her death. Further, the appellant had the habit of torturing her daughter off and on, and had also tortured her a day before the incident. PW3 also stated that she saw the appellant when she went to the place of occurrence. She also stated that the appellant was arrested by the police on her information after about a month. Subpara. The evidence given by PW3. No, the PW3 has not been confronted. By the appellant with regard to the truthfulness of her deposition. Truthfulness of her testimony is a testimony. Huh? As such, it is clear that at the time of it's clear that at the time PW3 went to the house of the appellant, she saw the dead body of her daughter and also saw the appellant in the said house. Next up. The evidence of PW5, the evidence of the IO, case IO, bracket PW5, is to the effect that the OC Difu Sadar police station registered Difu PS case number 102/2000 dated 21/6/2000 at 1 p.m. under section 302 IPC. On the basis of an FIR, and that the case was endorsed to him for investigation. He visited the place of occurrence on the same day and examined PW3 and other local persons. He found the dead body lying in an improvised bed made of bamboo inside the house of the deceased and made the inquest in the presence of witnesses. He seized 2 pieces of spotted sari with knot and another long piece of the same sari. These pieces were found besides the dead body. The body was then sent to Difu Civil Hospital for post-mortem examination. PW5 also states that the appellant was not found on the spot, that is place of occurrence. He further states that the appellant was arrested on 24/8/2000. Finding sufficient materials for prosecuting the appellant under section 302, he had submitted the charge sheet and other documents which were exhibited. Next part. The evidence of PW6, who was serving as who was the doctor working at Deepoo Civil Hospital, is to the effect that he conducted post-mortem examination of the deceased at 4:10 p.m. at about 4:10 p.m. on 21/6/2000. The deceased was about 21 years and he found the following on the body of the deceased. Page 19 and 20, 1, 2, okay. Oh. Just 1 minute. In the opinion of PW6, the death of the deceased was due to asphyxia, as a result of throttling. This spelling is wrong, okay. Throttling, out it is throttling. Yeah, throttling, okay. Arrow. It'll be TT, double T or double T LIGA. Out it and throat, then LIGA. Okay. Now you go. Nilake left, Nilake. Next para. The evidence of PW1, 2, and 4 is only hearsay evidence. In as much as they were not eyewitnesses to the crime. They had only heard about the death of the deceased. Next one. In the present case, we find that the death of the deceased. Now we find that PW3 had not been informed of the death of the deceased by her husband, that is the appellant, but by some other person. That is one Hasina Begum. Though PW5 had stated that he had examined Srimati Hasina Begum, Srimati Sumitra Devi, and one Hussein Ahmed amongst others, during his investigation of the case, the above three named persons have not been named, have not been made prosecution witnesses. Be that as it may, it is not the case of the appellate that the prosecution is hiding some fact from the trial court, which would not favor the prosecution case. Next paragraph. PW3, on being told of her daughter's death, had rushed to her daughter's house and found her dead on the bed. The appellant was also at home. However, when the IO went to the place of occurrence, went to the house of the appellant, the appellant could not be found. He could only be arrested 2 months after the death of the deceased. That is on 24/8/2000. The evidence of PW3 is to the effect that the appellant used to habitually torture the deceased and had also been tortured a day before the incident. PW3 has not been confronted with any suggestion made by the appellant to the effect that the evidence of torture was a lie and was false. Next one. The appellant, in his answer given to question number 5, during his examination under section 313, had taken a stand that he had found his deceased wife sleeping with another man. And he went to his mother-in-law's house, telling her that he couldn't keep the deceased as his wife any longer. Coming back to his house, he found his wife hanging. He took down her body for nursing her in the presence of his landlord. Full stop. However, she died while he was nursing her. On a careful reading of the explanation given by the appellant to question number 5 in his 313 CRPC examination, comma. We are of the view that no, we find that we are of the view that we are of the view that the appellant was present at the time his wife died, and that he had throttled her to death. Inasmuch as the evidence of the doctor is to the effect that the deceased had died due to asphyxia caused by throttling. The further conduct of the appellant after the death of the deceased, wherein it has been clearly shown that he could be arrested only 2 months after the death of his wife, also points towards the guilty conscience of the appellant, as he had apparently absconded. Full stop. He was only arrested on the basis of the information provided by PW3, as has been stated in her evidence, and which has also not been put to test by the appellant during first examination of PW3. Yes, Parag. The explanation given by the appellant to question number 5 during his examination under section 313 CRPC gives rise to an inference. No, it implies that the motive of the appellant for killing his wife was that he had found his wife sleeping with another man. However, there is no proof of the same. Full stop. no doubt, motive is important in establishing a case. Establishing a case based on circumstantial evidence. To start, however, in the case of Sukhpal Singh versus State of Punjab, 2019, 15 SCC 622, the Supreme Court has held that inability of the prosecution to establish motive in a case of circumstantial evidence is not always fatal to the prosecution case. More so when the accused persons could not establish any alibi or cogent defense. Next slide. No, continue. In the present case, the conduct of the appellant in being untraceable for 2 months, for more than 2 months after the death of his wife, leads us to believe that the appellant had absconded due to being guilty. No, has absconded due to his guilty conscience. Next. In the event that the explanation given by the appellant under section, with regard to question 5 in his examination under section 313 CRC is a false explanation. Then as held by the Supreme Court in the case of 1984 4 SEC 116. A false plea can at best be considered as an additional circumstance, if other circumstances point unfailingly to the guilt of the accused. Next part. The above being said, there being no eyewitnesses to the crime, and as the offense had taken place within the secrecy of the 4 walls of the house of the appellant. The same required the appellant to no, the same implied that the appellant was aware as to how his wife had died, correct? In section 106 of the Evidence Act states that. Further, in the case of Dash versus Dash, reported in 2006, 10 SEC 681.
Not in.
The Supreme Court has held
Yes.
Trimuk
That's it.
Maruti
Remember.
has held that if an offense takes place inside the privacy of the house,
21.
where the assailants have all the opportunities to plan and commit the offense, comma, it will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused.
Paragraph 15.
Paragraph
15 is
Prosecution to lead evidence may not be to that extent.
it held that though the initial burden to establish the case would undoubtedly be upon the prosecution, comma, but the nature and amount of evidence to be led by it to establish the charge cannot be of the same degree as is required in other cases of circumstantial evidence. The burden would be of a comparatively lighter character. It further held that in view of section 106 of the Evidence Act, there would be a corresponding burden on the inmates of the house to give a cogent explanation as to how the crime was committed. The apex court, the Supreme Court in para 22 of the said judgment has further held that where an accused is alleged to have committed the murder of his wife and the prosecution succeeds in leading evidence to show that shortly before the commission of crime, they were seen together or the offense takes place in the dwelling home where the husband also normally resided, comma, it has been consistently held that if the accused does not offer any explanation how the wife received injuries or offers an explanation which is found to be false, comma, it is a strong circumstance which indicates that he is responsible for commission of the crime. Similar decisions have been passed by the Supreme Court in the case of Nikka Ram versus State of HP, 1972, 2 SCC 80, Ganesh Lal versus State of Maharashtra, 1992, 3 SCC 106. That's all. I'm good. And it'll be and. Have we missed out something? Have we missed out something else? On considering all the above reasons and facts, we are of the view that the prosecution has been able to establish the chain of circumstances consistently pointing to the guilt of the appellant, and which is inconsistent with the attempt to prove his innocence. Accordingly, we do not find any ground to interfere with the impugned judgment passed by the learned trial court in Sessions case number 25/2000. The appeal is accordingly dismissed. Send back the LCRs, then amicus curiae fees.
Lordship has dealt with section 8 of evidence, perhaps.
Oh, we have not mentioned.
Oh, yes, section
Ah.
8.
Section 8, Section 8, give me the evidence act. Section 8 of the Evidence Act states as follows. Then we will put it where he runs away and all that. And that's all I think, only that part.
Only that part. Lordship had written those absconding and all
I've
those.
written that.
Only
I've-
8.
I'll just put that section in, I'll just. So you want this back?
This is Miss Bhuya and.
She needs it. She needs that and her diary.
There are other numbers. but- Oh, true.
Will come after 2 minutes.
Obliged.
Do we really able to examine? AR evidence no, I not Meghalaya is getting otherwise. But in Meghalaya, I'm not going Item number 2, B Prasad is not well, he cannot do.
B Prasad is not well.
Oh, but then he is there.
Actually, I am appearing, my lord, also.
Oh,
And B process is the amicus curiae.
Okay. You are the appellant's counsel.
Yes, yes. On last occasion also, my lords, the matter was posted by due to paucity of time. But today, I think, my lord, will be sitting up single bench, my lord.
Today I've got single bench.
Yes.
At 2 o'clock, we have
Yes.
this quite a few matters.
So if your lordship may fix it on 1st of August.
11 PWs and 3 DWs.
We will not finish.
Yes. If your lordship will fix it on a date, my lord, so that
Okay,
B Prasad may also be accommodated.
okay. On the prayer of Mr.
B Borwa, my-
B Barwa.
Yep.
Learned counsel for the appellant. And Ms. L Jahan, additional PP, this is the matter on 11th of
11th of August.
11th August, we have fixed.
August.
And the Das is not here since,
Not here.
I have not seen him since morning. Mr. NJ Das, he has 2 matters, 4 and 6.
I don't know why he's not coming.
No, he's actually, he practices a lot in the lower courts. Perhaps he's not able to manage. both
So
the
should we appoint
courts.
somebody else?
Whether he deals in criminal matters, that is how lordship allots.
No, there's no point, you see, because I have noticed that his matters were always adjourning.
Mhm. I can inform him.
Okay, right. No one, the learned amicus curiae is absent. Miss L Jahan, additional PP appears for the state. In view of the absence of the addition, learned amicus curiae, list the matter after a week.
I'll inform him to be here.
Then this one and also
6.
6 also. You have taken my cognate? Huh? You have taken.
Burman is here. May take your lunch.
Yes,
In this matter, my lord,
no eyewitness.
no eyewitness.
It'll take some time.
Yes, my lord, evidences are many, my lord.
Huh?
I have to,
Yes, quite thick,
yes, I have to read out all the evidences.
because this is circumstantial.
Yes. May I start, my lord, or lordship will take up any other?
Because I don't think we'll finish in 20 minutes.
My lord,
Jahan, you do?
Any eyewitness, madam?
no,
Lordship, one of the circumstances, he appeared before the IO. There were the evidence to that quarrel had taken place. Then one of the witnesses, he heard from somebody that Jahanuddin had cut her. These
Heard
are
from
witnesses.
somebody.
Yes.
Now, heard from somebody that hearsay. And quarrel between married couple, so it's part and parcel of
Yes,
their
at the
marriage
time
life.
of incident, deceased. and
Sometimes.
accused-
Looking at me. Maybe some of them, they're not married for a long time. No, sometimes there are quarrels. Not always maybe, but sometimes. So I don't know. So I don't know if you think we can complete, because I've got a single bench
Yes,
in the afternoon session.
yes. ठीक है, let me put it.
I don't,
You can-
Lordship, in the coming week, then.
Next week, my-
after a week, okay. On the prayer, the particulars, the matter after a week.
Public. ले लो. 8 to 2.
Huh? B Prasad, he's got a lot of cases and he's not well.
Which one? Angela.
B Prasad,
Okay.
B Prasad,
Yes.
right.
It will.
It is submitted as the bar that Mr. B Prasad is not well. Accordingly, leave this matter after the week. B Prasad, am I story?
May it pleases your lordship, in this POXO matter related matter, the division bench had passed an order, my lord. So, in fact, in this very matter, my lord, whereby it says that now the victim must be pleaded.
Doesn't say implemented, he just has to be informed.
Yes, my lord, if your lordship kindly see the order
Ah,
at internal page 7.
yes.
Yes, Roman 2, in every such bail application stroke criminal appeal.
On 31st. This is the problem now again. Again, the bench will have to be,
Because the lordship is sitting in the division bench.
I'm sitting in division bench, that's the problem. Otherwise, we can have disposed this of this matter also now. Anyway, this is the matter on 31st. Yes,
If I may place the instruction received by me through WhatsApp message, I just made a copy.
just a minute. Who is the? You are for whom?
I am for the IOCL, my lord has directed me.
IOCL.
Yes.
And you are working,
I am for the petitioner.
you are for the
I had
petition,
a pump, Indian Oil Corporation pump.
Indian Oil Corporation.
2013,
Ah.
the matter just refreshing your lordship in a quick, within 2 minutes. I had a pump. Thereafter, a letter of intent was issued, NIT was issued by BPCL. By BPCL, then we challenged it. We said,
BPCL is?
Bharat Petroleum, Bharat Petroleum. Bharat Petroleum Corporation Limited. Now, we
Respondent number, BPCL,
Three.
three. He says he's three, who is three?
But I am for and five.
Three.
You're 4 and 5.
Yes,
You're IOC,
IOC.
he's BPCL,
Yes,
three.
now, my lord, we filed a first writ petition on the ground that there is an office memorandum of 2011 where it said that the feasibility has to be studied before a petrol pump is set up. So the three oil companies has to sit together. Now there are respective NIT pulled by three companies. Then there was a first round of, there was an interim order which was passed by the court that on the basis they will not go ahead. They have to produce. Affidavit was filed, exchange, matter was heard. When the matter was heard, they produced a feasibility report before the court. Now we have seen the feasibility report. My pump was not taken into account. Then court said this is a new cause of action. I took a liberty to file a fresh. So we file a fresh writ petition before this honorable court. Now this matter is pending before this honorable court. We are saying, as on date, there is no feasibility has been carried out. This is our case. Your lordship want to see whether there is a participation of the Indian Oil Corporation. Feasibility is concerned. If there is a participation, I am out from this case.
If there's a participation or they have accepted the report.
Except then nothing is there to say. Now, one point my learned friend has pointed out, the maintainability of the writ petition. How am I aggrieved? Because why we should,
4 and 5 units.
yes, why I should,
Ah,
no,
but three.
yeah, three, what is the maintainability? Why am I aggrieved?
What right of yours
What
has been
right?
violated?
Because somebody is petrol pump, why you should be worried about it? You have a legal right. He showed one judgment of 1980 of this Guwahati High Court. At that time, when this matter was taken up, 1980, that office memorandum of 2011 was not there. The court said it has to be backed up by statutory some violation, then only you can come up to the court. That time 2011 was not there. That's my whole case. Now your lordship want to see whether that feasibility was carried out, whether they were participation to it or not by the Indian Oil Corporation. If they are participated, man, what case I have? I have no case.
But I think they have taken another ground also. That since you are working under the IOC. And,
Last- Yes. Last, yes,
And
yes.
you had, there was some agreement made, some clause was there.
Yes.
That you would, that you would not challenge or something. You would not make any challenge to the allotment. Made for another, what is that? For a retail outlet.
Yes. my lord, but.
What
kindly-
about that? What about that
No,
aspect?
I'll just, my lord, page 36, your lordship is 36.
No, let us go first. Wait, let us see the report.
No, let us see, my lord.
Have
no,
you seen the, have
before-
you what?
No, I have not seen. Before that, your lordship's order, your lordship's
It
order,
has- yes.
your lordship order was on consider submission made by learned counsel party. This
Ah.
court directs Mr. Bharadwaj to obtain instruction from respondent number 1. As to
From
whether
respondent
the-
number 4.
4, as to whether the feasibility report dated 15/11/2018 was placed before respondent number 4 and whether they were in the knowledge of the notice of appointment of regular rural outlet dealership dated 25/11/2018. He shall also clearly state respondent number 4 is objected to the feasibility report made by respondent number 3. That's what your lordship has asked for query.
So let us see.
This is the instruction from the senior manager law, my lord. The first, my lord, there
Yeah.
is no set mechanism, procedure, or practice for sharing of feasibility report and seeking of comments, clearance, objections, inter se OMCs on marketing companies. As regards the impugned feasibility report, the same was not referred to IOCL for comments. Since it is an internal document of BPCL, the IOCL did not know and could not know about its contents. As regards the submission before the read court regarding IOCL having knowledge about non-plotting of IOCL retail outlets, its source of information are informal chit chat during sidelines of industry business associations and from the submissions of the petition.
So what does that mean?
We just came to know from our brother colleagues in the similar OMCs, ma'am. In maybe in some conferences or that's how we came to know. That's why it was stated so in the affidavit.
That,
And regarding the feasibility report, madam, it was the procedure is not to share with us.
is not to be shared with you.
There is no mechanism for sharing. With it. And it's an internal document. We don't know its content.
So are you prejudiced by the, is there any prejudice caused to you by the feasibility report? No. Then if you are not prejudiced, how can the petitioner be prejudiced?
But if I am not prejudiced, madam, then he also he's a part
I'll
of me.
be-
That is what,
I'll
that's
be-
why I'm asking you. If you're, are you prejudiced by it?
No, madam.
No. Then how is the
Because we
petitioner
have not
prejudiced?
objected, my lord.
You have not objected to,
We have not objected.
though you knew about it
Yes. madam, the-
informally.
After advertised, after that it was advertised, madam.
Yeah.
Obviously, we came to know about it.
So you're not prejudiced.
My answer to it, my learned friend, is that they will not be prejudiced because they are person who is appointed. So they are interested only what they get it, what commission they get it. But why this OM has been issued? That's what I am saying. My learned friend is not giving a clear answer to the court. That whether this OM, well, let them give an answer to the court. We are not following this OM. End of the matter.
No, but then is that OM also enforceable
I'm
in a
sorry.
writ court? Whether it is enforceable?
Why
Is it-
not?
No,
Well,
there's
is there-
any statutory right comes out
My
of
lord-
that OM.
My lord, if there is an office memorandum, this is an office memorandum issued by the Ministry of Petroleum and Natural Gas. This is of 6th of April. That has to be complied by all the 3 Indian oil corporation. If my lord, I have no case, if they are saying that we will not follow, my lord, your lordship will close this matter. Let them say that we
Okay,
will not.
what about this submission made by the respondent number 3 earlier?
Yes.
That there was a memorandum of agreement entered between the petitioner and the IOC
Yes.
on 23/11/15,
Hmm.
where the petitioner had agreed not to dispute, object or challenge
Right.
the
I
appointment
have
of other
marked it.
dealers.
I have marked it. I have
Yes.
got an answer to it.
Yes.
We have no problem with setting up of a petrol pump. But their petrol pump to set up, I don't, today also I let them set up. But the OM has to be strictly for. Is OM, we are not saying that not to set up. Where we say that what to set up. What we are saying, that you set up, but please follow the office memorandum. You have not followed, that is why we have come up before this court. My lord, is Indian Oil Corporation is saying for setting up an oil corporate, any petrol pump, they will not follow the office memorandum. Why this office memorandum issued and specific chief executive officer of BPCL, HPSL, IOC. So this, for what purpose is of? Only for the purpose of carrying out feasibility report. The feasibility study will be taken off. I'm not saying, I'm agreeing to page 33. Yes, they can set up.
Page 33.
Yes, page 33. Page 33, your lordship is looking to 6192. Your lordship is, there are two repetitions which is,
Page 661.
6192. 92. That is, your lordship is about the clause, page 33, clause 4. Clause 4 at page 33. 4. The corporation reserve the right without reference or consent of dealer, one or more additional dealer in the same town, area, or location, and such additional dealers shall be entitled to make sale of the product without any objection of dealer and dealer, shall not be entitled to make any claim for remuneration, commission, allowance, whatsoever in respect of sale made by such additional dealer and or sale made by corporation through such additional dealers. Dealer hereby expressly further agree not to dispute, object, or to challenge the appointed dealer at the same place or at the any other place, either by corporation or by any other oil company or corporation for the time being operating in India. We are not challenging it. We are agreeing
Who is the corporation?
by corporations, my lords, either by corporation or any other oil company.
No, what is the definition of corporation?
Corporation, my lord. Doesn't have the definition. This is Indian Oil Corporation, will my lord. Where the corporate, kindly see at page 32. Page 32.
Yes,
Where the corporation carries on the business of refining and sale of petroleum products and more particular motor speed high diesel. So they are the corporation, Indian Oil Corporation.
where is the OM?
OM, your lordship will find at page 148. 148. 148. 6th of April 2011 to the executive officer of BPCL, SPS and IOC. New criteria for conducting of feasibility studies for new ROs, preparation of new marketing plan. Pursuant to the meeting taken by so and so on the subject mentioned above, matter has been further examined in the ministry. It has been decided that while conducting feasibility study for opening of new RO, preparation of marketing plan future, OAM will henceforth comply with the following condition. 1. OMC should consider the appropriate returns for financial viability of new RO, which from the gross margin available to OMs on MS HD is so and so. Now, your lordship goes on. Now, if your lordship kindly see at page 167.
Yes.
Kindly see, this is what they have submitted before the court, which I put to challenge. New retail outlet tracking system. NRO feasibility document. Document number so and so. Now, location kindly see on Patila Doha highway within 5 kilometers from so and so insertion. Now, it goes on. Now, kindly see at page 168. These are two, 168. Two BPC, this is Saini, IOC is AI, which my case is not been considered. Is not been. Now,
Where?
at page 168.
Yes.
168, trading area average, existing trading area also got it.
Yes.
Third column.
Yes.
That is OMC, oil marketing companies. That is one is BPC, Bharat Petroleum Corporation. The existing petrol.
Number, column number 2, you mean, not 3.
Yes, MS22. Lordship got it.
OMC MS22.
Yes, one is BPC, one BP Bharat Petroleum. These are oil marketing company. OMC retail RO name Saini. This is not the petitioner. And distance from so and so 6 kilometers. Number 2 is
What about AIE?
AIE is not us. Now this is now kindly see These are two which they have considered. Now, if your lordship sees at 173. Yes, this is, my lord will kindly see. This is number one, Chinese service station. Lordship got it,
Yes.
serial number one, Chinese service station.
Yes.
Number two is AI,
Hmm.
that lordship's seen Valley service station.
Yes.
And this is a proposed plot.
Proposed plot is that
Yes.
P.
Yes, proposed plot.
Okay.
Come to P. My name of the pump, your lordship will find at 183. My name of the pump.
But you're in the map in 173, you're on the
Here
straight
it's
road,
not showing.
going towards Guwahati.
Yes. My lord, yeah, now also I am telling my lord. Your lordship, I am saying that they have done it, is fine, they have, well, because why the feasibility was carried on in respect of two pumps, I am asking myself. Why my pump is not been carried on? This is my grievance. And I wrote a letter,
So basically, you're worried that your profits will go down.
this is what they said, let's sit together, decide. If they said no, your profits, they will, that's they made. Now kindly see at page 185. They said themselves, IO, Indian laws, kindly see 185. This is the reply when I made an RTI. All location of Patili, Doha, Ananta, so and so Ananta is not shown in the report, which is situated at a distance of around 600 meters on left hand side of while traveling from the point of so and so.
That is you.
Near me. Now, this is one letter by the IOC.
And this feasibility
today,
report
what-
has been made by
BPCL.
BPC.
Yeah, now today also I am saying what they can do is, today also they can they can sit together. They can make a report, and if they say it is viable, it's viable. Viable. Then I am out. Then there is no question of coming again to the court file. They can sit together also today also. Why they are shying off of sitting together? How much time it will take
I
for
don't-
feasibility?
Yes, yes. What do you say to the suggestion made by the, huh?
It can't be matter.
Why?
You say internal matter, assessment matter by the BPS only matter. It cannot be shared with the IOCL matter. After deciding the location matter, the BPCL matter only can only matter assess the matter location matter, whether there is a combined. You can get the combined.
No, but his case is,
It's a rural area matter.
Huh?
It's a rural area matter.
Ah, ah.
Can be see matter. The feasibility report matter.
So why, no, 1 second, I just give a reply, quick reply. My Langathan, it is confidential, it cannot be shared. If it is not then, 168, why you consider IOC? Why you shared the report with us? IOC kindly say 168, my lord. 168. Why you have taken my Indian Oil Corporation? Kindly see at page 168. OMC Oil Marketing Corporation. At page 168. Kindly see this, their report, BPC.
AIE.
Yes, BPC is Bharat Petroleum and Indian Oil Corporation, number two. Why you are sharing this report to us then? Is internal. You should not share it. Today you are sharing, it cannot be. We cannot share it. But you annex this report. And this they said we have taken into consideration. Why my pump is not taken into consideration? My pump has not been taken into consideration. If they can share Indian Oil Corporation dealers pump, why not my pump? This is my case. And my learned friend is saying that we cannot share it. If you cannot share it, then you could not have mentioned IOC. This is a report, because this is a report he has furnished before the court.
Yes.
Sharing and receiving of data from IOC is two different aspects.
No, you see, one thing, when you made the feasibility report in page 168, you also considered this IOC, this AIV 5, whatever.
So we have
If-
taken a data, my lord.
Huh?
We have taken a data from there, my lord.
So he's saying that why didn't you take his pump also, keeping in view, please try to listen also.
Yes.
Keeping in view the OM issued by the central government on 6th April. Now, what bars you from considering taking a decision on the basis of this OM?
We have,
Page 168.
we have carried out the feasibility, madam.
And why his pump was not considered, we have explained in our affidavit also, my lord.
Yeah, what was that? What is the reason?
The It's page 189, madam. Para 8, madam.
Page 189. Which case? The other case?
In madam 6192 of the 22, madam.
Yes.
Para 8, madam. Page 189, madam. It's a running page, madam. In Kopita Das.
189, yes,
May I read that?
yes.
That with regard to the statement made in paragraph 9 and 10 of the repetition, the deponent said the location for setting up regular and retail outlet have been identified as per the guideline enumerated in PSU Oil Marketing Company Manual for selection of regular and rural outlet dated 24/11/18. Clause 1 of the guideline provide the procedure as to how the location are being identified, and for ready reference, same is expressed below. Identification of location. Location of setting up retail outlet are identified by the respective oil company based on commercial minimum volume consideration. Current volume norms are as under. This proposed pump is under rural method. Clause 4 method, rural retail outlet E-class expected combined sale volume 25 KL per month method. And feasibility of the location would be carried out by the deponent corporation to examine the average sale of the trading area, which should suggest to get the expected combined sale volume and estimated sale. Subsequently, upon approval of the feasibility study, the location is being advertised. So far, guideline 6411 is concerned, the deponent said the Government of India, Ministry of Petroleum and Natural Gas requested the oil marketing companies to comply with the condition enumerated in clause 1 to 3 at the time of conducting feasibility study, so that adequate financial return would be included from new regular retail outlet proposed to be set up in a marketing area except the real retail outlet. The deponent stated the three conditions as in clause 1 to 3 are not required to be complied, which as real retail outlet are given adequate financial return to the OMC. Is the
So according to you, these guidelines would only be applicable to urban area, is it?
yes, madam, and it is talks about about the financial liability of the corporation only, madam. In the present case, the location of so and so has been advertised by the deponent corporation under E-class market, and expected combined sale volume of the rural retail outlet is 25 KL per month. And in the guideline that is so and so, a feasibility study was done which recommended to set up a new rural retail outlet in the advertisement location. Particularly, while conducting feasibility study, the deponent corporation considered the nearby retail outlet of the advertised location to arrive at sale potential. Considering only two retail outlets, one BPCL and one IOCL, sale potential would become at 63 KL per month, which is above the required projection to advertise under rural category. It is to be mentioned here that the deponent corporation did not consider the petition retail outlet, which was selling 100 KL per month at the time of conducting the feasibility study. However, if petition retailer would have been considered during the feasibility analysis, the proposal for one more retail outlet apart from the one is already advertised would be advertised in the state as per guidelines so and so. So, if petitioners retail outlet is be considered, then we can also can set up a new one new retail outlet.
That is a different issue.
Yes, madam. But the petitioner cannot insist as to how we should conduct feasibility study, because these are the technical person,
Okay, there's only one thing. So this, according to you, this office memorandum is not required to be followed.
But if feasibility study was done and it says, about the
Let us see again this,
Yes, madam.
let us see this office memorandum, page
says,
140, page 148.
140. No, they have done this, feasibility was done. At page 191, which my learned friend has said, they rely on the OM. Otherwise, they would not have written in the affidavit about the feasibility part. They said we have taken into consideration a two pump in their affidavit at page 191. They have not denied that they have not taken. That means on the face of it, they are minor complying with the OM. It is their own affidavit at page 191. Your lordship read that.
So they're complying, so.
So why that my pump was not complied? They said two retail outlet with one BFM IOCL sales potential will come. What about mine? They have not complied with this mine. So they cannot deny, now they cannot say the OM is not applicable. Page 191, kindly see my lord. I am thankful to
No,
my
but-
learned friend at page 191 of the of his addition affidavit which has been filed. Kindly see my lord 191.
I don't have 191.
190 this
Okay,
is
that is evidence.
yes, his affidavit 191.
Yes.
Kindly see the second paragraph. In the present case, the location on Patila Doha Highway within 5 kilometers from has been advertised by Nippon and Corporation under E-class market and expected combined sale volume of the rural retail outlet is 25 KL per month. And in view of the guidelines, feasibility study was done, which recommended to set up a new rural retail outlet advertised location. Pertinently, my lord, while conducting feasibility study, the deponents corporation considered nearby retail outlet of the advertised location to arrive at sale potential on considering only two retail outlet, one BPCL and one IOCL. Sale potential would come at 63 KL per month, which is above the required projection to advertise under rural category. It is to be mentioned here, deponent corporation, the corporation did not consider petition retail outlet which was selling 100 KL per month at the time of conducting feasibility study. However, the petition or retail outlet would have been considered during feasibility analysis. The proposal for one more retail outlet apart from the one already advised could be advertised a stretch of so and so. So they are imagining this, which this will come to 100 KL at the time of conducting. So it is apparently they are following the OM, which my case was not considered.
There is no such guideline, which recommends there his petitioners should be considered at the time of carrying out a feasibility report. We'll see what is the relation between petitioner and the IOC. It's a principal agent. See the principal agent. Since the principal has not objected, how can the agent can have objected? Besides, there is a clause in the agreement of official that the agent cannot object. Now, kindly see 148.
Yes. Yes.
This says new criteria for conducting feasibility study for new retail outlet and preparation of new marketing plan. Pursuant to the meeting taken by Secretary so on 15/11 on the subject mentioned above, the matter has been further examined in the ministry. It has been decided that while conducting feasibility study for opening new retail outlet preparation of marketing plan in future, OMC will henceforth comply with the following condition. The OMC, oil marketing companies, should consider the appropriate return of financial viability of new retail outlet, which from the gross margin available to OMC on MSSD is rupees 354 per KL. So it talks about about the financial viability of the OMC. What would be the return? Come to the OMC.
Next.
The OMC should be greater emphasis on setting up a B-side retail outlet in preference A-side retail outlet. I am posing for a moment here, madam. What is B-side and A-side? It is reflected, madam, in in 64, madam.
Page 64.
Yes, Madam, come to page 67, madam. It's a part of madam brochure, madam.
Yes,
Type of retail outlet. The type of site will be decided by the oil company and same would be, madam. First, location under corporate fund scheme CFS. The offered land would be taken on lease, purchased and fully developed as corporation own site. Other corporation own site, so in A site. The offered land would be taken on lease, purchased and fully developed as corporation own site. Dealer own site. B side, ma'am. The offered land under superstructure will be developed by the dealer, pump, tank, information, signals, etc. will be provided by the corporation. Now, madam.
yes.
On how it is to be differentiated, madam, page 78, madam. What are the facility would be provided by the madam, the company and madam, the dealer itself, madam, in A side and B side, madam, page 78, madam.
Huh?
Page 78, madam.
Yes. Yes, page
It is
70.
categorized the madam, the A side and B side, madam. On A side, madam, develop land with boundary compound wall as per corporation is the dealer. The who provide them a facility, madam, in A side and B side, madam. This is categorized, madam. Now, madam, coming to madam, page 148, madam.
Yes,
The OMCs should give greater emphasis on setting up B side RO in preference to A side. In B side, madam, the dealer has to madam, develop entire madam,
okay. Next.
as cost would be much lower while return would be similar. It is for the oil company. OMC will have to work out a compensation mechanism for B side retail outlet where a dealer is compensated adequately. The OMC may work out a mechanism where executive director retail of the 3 OMC may decide by the consensus of expansion of network in new area like developing sub in city, new highway, road bypass, diversion or area like developing sub in city, new highways, road bypass, diversion areas showing very high growth and existing infrastructure is adequate. Number 4 is important. Next, please. No restriction may apply for retail, rural retail outlet, who is are anyway low cost retail outlet are given adequate returns. These are the differences, madam. Now, how madam the feasibility would be madam carried out, madam? This is a policy decision, madam, for the corporation itself, madam.
So basically, 148, the serial 1.
Yes, madam.
Talks of OMC should consider appropriate returns of financial viability of a new RO, which form the gross margin available to OMCs is 354 kiloliters. That means the new RO has to be able to sell 354 kiloliters. That's what. So it does not have to, according to you, consider whether those existing other ROs
Yes, madam.
under different OMCs are having the minimum sale or not. That is their problem, not your problem.
Yes, madam.
Yes,
Well, this is I am relying on the administration views as well.
yes.
Page 2022, my 11 SCC, page 1, madam.
2022,
11 SCC, page 1, madam.
Page?
Page 1, madam.
1.
1, madam.
Tara,
Madam. 539, madam.
539, para 539.
Yes, madam. It is central visa project, madam.
It's quite a long document.
540 is important, madam.
Huh?
540, madam.
Yeah.
It pays.
Yes,
May I read, madam?
yes, yes.
A tender is essentially a contract between two parties and merely because one party of the contract is the state, the basic character of the transaction does not change. In India, we follow the principle purity of contract and the law relating to contract and specific relief provided ample remedy to an aggrieved party to the contextual transaction. The principle of purity of contract has sound basis in law. It is owing to the basic contract of the commercial relation where two parties of sound mind choose to enter into a legal relationship with each other and decide mutual rights and liabilities in accordance with the needs of the transaction with their free consent. There is an element of consensus at in a free commercial transaction. It is the foremost desire of the parties to keep third person interference away. Then my 540. As general rule, there is no locus for third person to question a free contextual relationship. In special circumstances, no doubt the special relief act provides for circumstances when any person could initiate action for rescission of contract or cancellation of instrument. However, this action is available only if the initiator is able to show that the contract instrument is detrimental to his interest. Moreover, that is a remedy to be pursued in civil court or the court of first instance. There is no basis in law to permit a absolutely unaffected person to seek a settled transaction between two parties. Here also, the petitioner is a third person, madam. He has no legal right, madam. Because, madam, the OM, madam, is not a issue, madam. Madam. Because, madam, we have the right, madam, to do business also, madam. If there is any violation, madam, it has to be restricted by any state, madam. Yes. Madam. Huh? 540. 541, madam. 540.
Huh?
541, 542, then madam, 547, madam.
Just a minute. Tell me everything, one go, I have closed my book. $541.
540.
Any other
Madam.
paragraphs? How many
Yes, ma'am.
paragraphs? Tell me all.
541, 542,
541, 542.
then madam, 547, madam.
Anything else?
Yes, madam.
Any other paragraph after 547?
No, madam. Last paragraph, madam, 547, madam.
Yes.
It is relevant to note that the question of Lucas in considering an argument on this nature cannot be sidelined, for such argument call upon the court to expand the conclusion of jurisdiction to venture into strictly private commercial matters. A litigant not being a party to transaction cannot hard in ordinary circumstances. What needs to be established is substantial and demonstrable public interest on the basis of a concrete factual position. The jurisprudence evolved by this court in such a matter looks for substantial public interest to be shown on the basis of violation of part 3 of the arbitrariness in government action. In the absence thereof, it becomes the duty of the court to preserve free commercial relation. So, madam, the petitioner here also, madam, could not show that any public interest has been increased, madam. Any right has been increased, madam, for the petitioner also, madam.
So basically, no, out here he's saying that the OM has not been applied. Now, this OM.
What is it?
Where does it say that this OM has to be, this feasibility report has to be shared between all the OMCs?
I'm sorry.
Where does it say that
Yes.
this OM has to be, the feasibility report made on the basis of this OM has to be shared between all the OMCs?
No, that's the OM itself is fixed, my lord.
Huh?
OM itself is fixed. How can an expert feasibility will be taken by
No,
one of the
no.
companies,
No,
one of the oil marketing
no, let
companies?
us read the OM.
Yes.
OM says.
Yes.
For new ROs, preparation of new marketing plan. It only says what is to be done
Yes, madam.
for making a feasibility report. It does not say that the feasibility report has to be shared between all the OMCs.
No, when my lord, a pump is set up,
Ah.
a pump is set up.
Ah.
Suppose I have an Indian Oil Corporation pump, my learned friend has got a BPCL pump.
Correct,
Now they want to set up more in Indian Oil Corporation very nearby.
correct.
Now the purpose of this OM is to find out what is the earning that A will get, B will get, and
No,
C will
no,
get.
it is only with respect to what the new RO will get.
No, that's what I'm saying, right? New RO will get.
Ah.
It is, but it will be seen. That is why that feasibility has to be looked into it of the pumps which are existing.
Correct.
Well, not only the pump which they are going to set up. The OM, why this has been done, my lord? This has been done because there is no study in it. They'll put 5 petrol pump by nearby. Maybe I am owning a petrol 2013. My lord, everyone has got right to business. There is absolutely no problem in that. 2021 they advertise a new pump. But my lord, there are 5 pumps. That is why this OM has come into effect, my lord. That this OM has to be given effect to. Further, if your lordship kindly see now,
Okay,
151.
so his basic case is that for you to come to a decision that the new RO will be able to have a gross margin of 354 kiloliters per month, I think. Per month or per year? I don't know.
Per month.
Per month. Per month or per year?
No, no, per month, I think.
This document, my lord.
Page 148.
148.
Go to 148. You see the first number 1.
Yes.
The OMC should consider the appropriate
Viability
return
of
of
so-and-so gross
financial
margin.
viability.
OM on so and so
It's per
rupees.
kiloliter, my lord.
Kiloliter per
Kiloliter.
month or per year?
Yes.
Anyway, it says kiloliter. This decision can be made only after a feasibility report has been made of the other pumps in the area. That's what,
They were.
does
my
not
lord,
say exactly other pumps
my
in the
lord,
area.
they were not doing it. So what if 151 kindly be seen on page 151?
Just a minute.
Yes.
But it does not say that other pumps in the area should be considered. It just says the feasibility will study for marketing plans, and so they should consider the appropriate returns for financial viability. Okay, so the petitioner's cases, since they have considered 2 petrol pumps for coming to a finding that it is viable to open a new pump, why didn't you consider his petrol pump? That's all.
Let there be a situation, my lord, where there is no my lord, petrol pump, my lord. If they are supposed to set up a new petrol pump. What will be the my lord, feasibility study, my lord? That will see, my lord, in. But then, my lord, the oil company, my lord, we conduct a survey, my lord. What is the growth of that trading area, my lord? Here also we have taken this, my lord, data also, my lord. How, why, my lord,
Anyway, the basic grievance of the petitioner is that he is going to make a loss at the end of the day.
No, they were not carrying it because at 151, and again, a direction is given government of India. See 151.
if we go for a my lord, face my lord feasibility, he will be the loser, my lord.
No, it's
We
not
can
like
install
that.
one more petrol pump, my lord.
I'll accept it. What is there? I'll accept it.
Ultimately,
151.
is a business sensation, my lord. We have
Huh?
to, ultimately, it's a
The business
decision.
decision.
Yes, my lord.
And it is not your lookout to see whether he survives or not.
Yes, my lord.
It's a rival.
Yes. Madam, kindly see, my lord, page
That
169.
is what business is all about. It is not his problem whether you survive or not.
But the problem that has been created, whether I will survive or he will survive, that is why some mechanism is given by the government of India. Otherwise, I would not have any case before the court. Because 1980 judgment, of which my learned friend has said, that I don't have. Somebody wants to put a petrol pump, they can put a petrol pump. Why this OM is required? 151, kindly see, my lord.
So what is the problem in
Yes,
having what is the problem in having a feasibility report in considering his pump also?
But I have already shown, my lord.
What? Yeah,
We can also, madam, we can again, madam, go for a installation of new petrol pump in that area, madam.
you do it.
By
You do that. You open another.
That's why I'm saying it's a business sensation, my lord.
Huh?
The return would be, my lord.
No,
lesser, my lord.
you see, his case is very simple. His case is you have taken a decision to open a new RO by looking at the 2 petrol pumps. He says that 3 petrol pumps which includes the petrol petrol pump should have been included. Why only two? Why not three? Because they are close by.
That's why I'm repeating, my lord. Only asking my lord to show a guidelines or any document, my lord, which suggested, my lord, is the petrol
Petrol pump has to be
my lord.
considered.
Because
There's
my-
nothing like that. There's
He is a
nothing.
licensed or agent, my lord, since the principal has
Principal
not
has not
objected, my lord.
objected.
How can the agent can, my lord, because objected, my lord? And this is how it is to be carried out, it's a policy decision, my lord. In this aspect, my lord, I'm also relying on one more than my lord. 2020, 18 SCC, 527, my lord.
5 SCC.
Yes.
Before my lord, you contacted, my lord, section 211, my lord. Of the contact, my lord. May I read, my lord?
Yes.
Section 211, agent's duty in conducting principal business. An agent is bound to conduct the business of his principal according to the direction given by the principal, or in the absence of such direction according to the custom which prevailed in doing business of same kind at the place where the agent conducts such business. When the agent acts otherwise, if any loss to be sustained, he must make it good for the principal. If any profit cost, he must account for it. So, my lord, since, my lord, I'm saying, that's why I'm saying, my lord, since the principal has not objected, my lord, he has to act as per the direction given by the, my lord, IOCL, my lord. Okay.
Yes. Anything else?
Yeah, para 18, my lord.
18.
Yes, ma'am.
Yes.
But it starts, my lord, in bottom, my lord, it is settled that para 18, my lord.
Yes.
It is settled law that policy decision of the.
No, this is 2020.
Yes, my lord, 18 SCC, my lord.
Ah,
527.
para 20, para 18.
18, my lord.
Para 18, bottom.
18 SCC, 527. 527.
It is well accepted principle.
It is settled, ma. It is settled law that policy decision of the executive are best left to it, and the court cannot.
Wait. Can I use it?
Para 18, ma. From bottom, my.
Para 18 starts with going by the
Going by the-
aforesaid consideration.
The third line, ma.
Ah.
It is settled law that
Okay, so you said bottom, that's right. Okay, it is settled law, okay.
the policy decision of the executive are best left to it, and the court cannot be propelled into the unsettled ocean of government policy. Public authorities must have liberty and freedom in framing the policy. It is well accepted principle that a complex.
He is not going into the policy decision. He is saying that you follow the policy. You see, he's saying that the manner in which you have followed the policy decision is not fair. You have only followed it to the extent of considering 2 petrol pumps, while you should have considered 3 petrol pumps. That is his case.
He is not urging any question of malafidness on our part, my lord.
How does it matter?
Yes, my lord. Until unless, my lord, our policy is malified, my lord. Because in subsequent, my lord, para, my lord, see, my lord.
Okay, yes.
It is well accepted principle that in complex social, economic, and commercial matters, decisions have to be taken by the government authorities, taking in view several factors. It is not possible for the court to consider competing claims and to conclude which way the balance like. Tails court are really keep.
This is not with regard to the policy matter. There is no challenge to the policy.
Yes, my lord.
He is not questioning the policy. In fact, he's saying the policy has not been followed. That is his case. He is not challenging the policy.
No, my lord, as per the petitioner, my lord, his contention is that, my lord, we have not paid out the, his.
They have not carried out the feasibility report as per the policy. That is his
There is no such policy. This is our internal
He
policy,
says
my lord,
that
as
the
to how-
OM is the policy.
But it is a duty of the, my lord, petitioner to bring a, my lord, a letter or guidelines, my lord. That's why I'm saying, my lord. It is an internal assessment, my lord. How it has to be done, my lord. Because these are the technical person who have conducted the feasibility study, my lord.
But what about the OM? Is it a internal policy?
Yes, my lord, kindly page 66, my lord. What has to be done, my lord, for identification of location? Page 66, my lord.
Page 66. Yeah,
Identification of location. Location for setting up retail outlet are identified by the respective oil company based on commercial minimum volume consideration. So our minimum volume consideration per month is 25 KL, my lord. We got, my lord, 63, my lord, per month. Huh? By, my lord, taking into consideration 2 petrol pump. We the proposed location, my lord. We got, my lord, 63, my lord, per KL, my lord, per month, my lord.
where do you get 63 KL per month?
Kindly see page, my lord, 167, my lord. In para 8, we have history, my lord. In feasibility also, my lord.
Page
Page, my lord, 168, my lord.
168. Of which case? Okay, 168, yes. Where is the minimum?
My lord, come, my lord, from, my lord, 167, my lord. I just see my class of market in right hand side, my E class, my lord.
Huh?
Class of market, my lord, in right hand side, my lord. Class of market, my lord.
In page 167,
Yes, my lord.
class market.
Class of market, E class, my lord. For E
Class
class market, my lord, the combined sale volume would be, my lord, 25 KL, my lord.
Where do you get the 25 KL?
I have listed in para 8, my lord. As per our, my lord, own, my lord,
As per para 8 of your affidavit.
yes, my lord. Rural retail outlet plan. E class, my lord. Expected combined sale volume,
Which page? What?
page 190, my lord.
190? Yes. Where?
Rural retail outlet, my lord, E class. Expected combined sale volume 25 KL per month.
Then, Mr. Council, just keep this in mind, 25 KL
Yes.
per month. Now come to page 148. Come to the first point.
Point 1, my lord. I do. In this,
The OMC should consider page 148.
only here, my lord, clause 4 will apply, my lord.
Okay. Clause 4, this will not apply to,
Not apply, my lord.
okay.
Clause 4 for, my lord, rural retail outlet, my lord.
Okay, okay. So according to this, so this 354 will not apply.
Yes, my lord.
And what is the internal things we were supposed to do? The manner of your feasibility report has to be done internally.
Yes, my lord.
You said that it is the guidelines
Yes, my lord.
of 2018. Where is that? Have you given me a copy? No.
Last time I have given my lord.
Last time you did.
Return it.
No, no, if it is, it should be
Yeah.
here. No one will take it. No one wants it. Yes, now, which is the relevant portion of it? Because you said that this is the guideline followed by you
Yes,
for making the feasibility analysis,
yes, my lord.
which is the relevant portion. I cannot read
First page,
181 pages.
first page, my lord.
First page.
Identification of location.
Okay.
On the same, my lord, expected combined sale volume 25 KL.
25.
And the next page, my lord, feasibility of the identification location would be prepared, my lord. By concerned division, regional and territorial office, my lord.
Let us see this initial A and 2. Where is it page?
No, I have flag mark.
In issue A1, okay, in issue A1,
Report on feasibility. my lord.
page 41.
Yes, my lord. This is the format, my lord.
But IOC are there. BPC is there, HPC is there.
Yes, my lord.
Then
Any private entity also, my lord, that if there is any private entity, my lord, like my lord,
they are a private entity.
if it is there, my lord, any private entity near the vicinity, my lord, then also that.
Then is they are the private.
No, they are IOCL, my lord.
Huh?
They are IOCL, my lord.
So you come to this column
Yes, my
on
lord.
the right hand side.
Oil company, my lord, IOCL, BPC,
Ah.
SPC private, my lord.
Correct.
IOC, BPC, SPC private, my lord.
So what does it mean? It means that they have to be considered also. It has to be considered.
Yes, my lord. Yes, my lord. It says about, my lord, the that, my lord, the data of, my lord, the oil company,
Huh?
maybe, my lord, considered, my lord.
Maybe.
Because it's a guideline, my lord.
He's not relying.
No, I am relying, my lord. As
not
per the
relying.
format, my lord, it was considered, my lord.
Now you see, this shows that you have to consider. Only thing is
If it is not
only one
considered, what had
argument.
happened, my lord?
Huh?
But if it is not considered, my lord, what had happened, my lord?
I do not know. I'm just saying that this is
Because, my
their.
lord, our only intention to get my 25 KL per
No, no,
month.
I agree.
Yes,
I agree fully.
Yes, my lord.
But when you have set out a form for yourself,
Yes, my lord.
isn't it required that you should fulfill your form as it is? Because this is, you said that your case was, we have got our own system of making the assessment, internal assessment, which I cannot show them. And accordingly, once we fulfill our internal assessment form, it has to stand as it is. And you said that the office OM is not applicable because it does not apply to rural ROs.
Yes, my lord.
Now this court agreed with you in a way. However, when looking at a form, there is this IOCs, there BPCs, there HPCs, there private is there.
But it is not necessarily all the, my lord, oil company, my lord, who are situated near the vicinity, proposed location should be, my lord, considered, my lord.
How do you say
Because, my
that?
lord,
Who?
well, kindly see. my lord,
Where have you said that
my
in
lord,
your
we are only
affidavit?
concerned the minimum.
Where have you said that in your affidavit? Can you say it? That all cannot be considered? There has to be a
In
limit.
paragraph 191, my lord, second paragraph, my lord. In present case, the location of so and so has been advertised by the different corporation on the E-class market. And the expected combined sale volume of the rural retail outlet is 25 KL per month. And in view of the guidelines, so and so feasibility study was done, which recommend to set up a new rural retail outlet in the advertised location. Particularly while conducting feasibility study, the different corporation considered nearby retail outlet of the advertised location to the arrive at a sale potential, considering only 2 retail outlet, one BPC, one IOCL sale potential would come 63 KL per month. Which is above the required projection of the advertised under rural category.
Now, supposing you consider 3, it might have come less.
It will be more, my lord, because wherever.
No. It's like this. Supposing I'm selling 100 ice creams. If there is another shop built next to me, naturally my sales will go down. If there are 2 shops, it will go further down. If there are 5 shops, it will go further down. Unless your population also grows proportionately. So similarly here, if you had considered, you considered two outlets, you got 63 kiloliters. Now supposing you considered 3 outlets, it might have been less. It might have been less.
Divided by 3, my lord, and it will be more, my lord. Above my 25 KL, my lord.
Yeah,
It will be more than my 25 KL, my lord.
it could happen, we don't
Yes,
know.
my lord.
We don't-
Because that's why I am saying it's a business transaction, my lord. We have also see our, my
No,
lord.
that is one
Yes.
thing. There is only one aspect of the matter.
Yes, my lord.
That it doesn't appear to have any right. But then on the other hand, your form itself,
But serious, my lord, my lord say.
but
Yeah,
then there is one, there
The
is,
private, name of the private entity are also inside, my lord. Since there is no such private entity, my lord, near vicinity, my lord, that's why it was not
what
considered, my
is the,
lord.
what is the distance between the new RO and the petitioner's RO? That could have a bearing.
As far as petition is concerned, my lord, it says, my lord, 4 kilometers.
4 kilometers. Now, you see, one thing is that the ROs to be considered, I mean, not new, the old ROs to be considered. We'll have to know what is the, like, there has to be something that how, what the distance of the ROs to be considered. Whether it should be 100 meters, 200 meters.
300 meter, my lord.
300 meters.
300 meter.
Okay.
Indian Congress, my lord. Okay.
So where
But
is
it-
that? Where is that?
But it was not even considered Assam, my lord. Oh, yeah.
Huh?
In MP, my lord, it was considered, my lord, Indian Congress.
So, where is that? That is, the ROs should be between a certain distance between each other.
It's not there. It's not there, my
But
lord.
there has to be. There is, I think.
But it was not
I
followed in
think
Assam,
there
my
is,
lord.
huh?
It was not followed in Assam, my lord.
Not followed.
It has to be, my lord, followed by the PWD, my lord. But there is no notification in Assam, my lord.
Out here, the distance between
Two
you are 4
It
kilometers.
should be 300 meter, my lord.
No, out here it's 4 kilometers. Between the petitioner's outlet and the new outlet.
Within years.
Now, if it is 4 kilometers, the question arises as to when a feasibility report is to be made. The petrol pumps that are to be considered, they should be at a particular distance from the new RO. You cannot, it should be either 1 kilometers, 10 kilometers, 15, it cannot be 500 kilometers or something. So what is that minimum
It will be, I think there
distance
is,
required for consideration? There has to be something.
it is, my calculation is 800 meters. If you see at 173 Milo, the drawing which we have given. P is a proposed, kindly see 173. How much to come to us?
173, yes.
173 proposed P. P is 1.8 kilometers. This road is Patali Doha Road, location, kindly see. Road, Patali Doha Road, this.
Yes, yes, I know.
Here. Mine is 1 kilometer from highway.
1.8.
Yes.
No, you see, the question is this. Now, supposing,
Hey, this is 300 meter, my lord.
300 meters. Where?
Finally, one dustbin, my lord.
Yes, yes,
There are 14 miles.
there are 14.
Earlier it was 1,000,
Yeah.
1,000 meter, my lord. Now it is 300 meter. As per Indian, my lord, Road Congress, my lord.
Yeah.
For about issue number 1, what the collector so is justifying granting NOC by letter in favor of the SPC under 144.5 of petroleum rules. It is what are to the relevant rules. So Indian Road Congress, with 9 guidelines on which mass reliance has been placed. Now I will see my lord. In my lord, next page, my lord, in third page of my lord, the above mentioned distance are in
No, give me the distance. Don't,
the
don't.
above
give me-
mentioned distance are applicable for setting up a fuel station along with the national highway, state highway, major district road. In case of fuel station along with a rail road in plain and rolling terrain, the distance from the intersection which so and so can be reduced to 300 meter in place of 1,000 meter. Sir, I know, my lord.
Huh?
I know, it should be like 300 meter, my lord.
You know, but I don't know, no, can I go by what you know? I hope you understand my
Yes, yes.
question. When you're going to make a feasibility report and you've got to consider the viability of the new RO. And you're considering the other ROs. What should be what it should be the distance of those ROs to be considered?
It is a net also. Maybe.
Huh?
It is in the net, Google also. Maybe. I just.
So should I ask Mr. Google?
No.
Okay, right. Anything else?
These judgments, if I learn it,
They-
these
they
are
are-
not
they-
applicable.
They're not much. They're-
This is nothing to do with,
Yes.
it doesn't, my lord, say at all, my lord, I have gone to that 541, 542 paragraph. Those judgments will not be applicable in our case. This is regarding about a tender. You didn't
Yeah,
participate.
they're
but-
general law.
General
general
law. It is human kilometer.
Who is the respondent number 3? You're the 3. Yes. Okay, right.
Other day, I have submitted the judgment regarding the maintenance of that.
Okay, okay, anyway, we'll see. Mr. P. Bhardwaj, Learned Counsel for the respondents number 4 and 5. 4 and 5. Submits that there is no set mechanism, procedure or practice for sharing the feasibility report made by one OMC with another, or seeking comments and clearance or objections from the other OMCs. Full stop. He also submits that the impugned feasibility report made by the respondent number 3 had not been referred to the respondent number 4 and 5 for comments, since it is an internal document of the respondent number 3. Mr. P, the counsel for the respondent number 4 and 5, however, submits that the respondents number 4 and 5 were aware of the feasibility report made by the respondent number 3 due to having gained knowledge informally. Huh?
And after filing of the report.
and formally after the filing of the writ petition. He submits that the respondent number 4 and 5 does not have any objection to the feasibility report made by the respondent number 3. And with regard to the notice dated 25/11/2018 for opening a new RO by the respondent number 3. Correct? Next. Mr. D. Das, learned senior counsel, submits that in terms of the OM dated 6/4/2011 issued by the Government of India, Ministry of Petroleum and Natural Gas, the feasibility report to be made by an OMC to open a new RO requires that all the neighboring ROs should be considered. First up, however, respondent number 3 has not considered the petitioner's petrol pump, which is in the neighborhood of the new RO to be opened in pursuance to the notification dated 25/11, no notice dated 25/11/2018, while on the other hand, R3 had considered 2 petrol pumps, one belonging to IOC, while making the feasibility. I think that's the case. He submits that either the respondent number 3 fully complies with the office with the OM dated 6 April 2011 or does not comply with it at all. Next para. Mr. S. Bhattacharya, learned counsel for the respondent number 3. On the other hand, submits that the IOC not having objected to the setting up of the new RO in terms of the feasibility report dated 15/11/2018 and the notice dated 25/11/2018, the petitioner could not have made any objection to the same as he was bound by the memorandum of agreement entered into between the petitioner and the IOC on 23/11/2015, wherein the petitioner had agreed not to dispute, object or to challenge the appointment of other dealers at the same place or at any place, either by the corporation or by any other oil company or corporation being operated in India. He also submits that the new RO to be opened. Next para, he also submits that the new RO to be opened by the respondent number 3 pursuant to the notice dated 25/11/2018 was to be done in the Where is that B site, A site? Govind? Page? Page
66,
67, huh?
Page 66.
Was to be done. No, no, what have I said?
67, my lord.
No, was to be, was pursuant to the census, notice dated census, was to be a rural RO. Wherein the minimum. Where is that 67 kiloliters?
Yes, madam.
63 kiloliters or 67
Para 8,
kiloliters? Huh?
Para 8, madam.
Para 8.
Yes, please. 191, madam.
But where is it in the, no, not in the document I want.
Yes. The feasibility report, madam. One 68, madam. Trading area average sale, madam. MS, madam, motor speed, madam.
Huh? Wherein?
22 and 41, madam, plus minus 63, madam.
168.
168, madam. Trading area average sale, madam.
Trading area, where's trading area? Average.
MS 22, SSD 41. Detail, madam.
Wherein the. Average sales. In kiloliters in the trading area. Of the new RO, of a new RO was supposed to be 63 kiloliters, is it?
Yes.
No, this is 63 is what is going to be sold. What
Ma'am.
is the minimum requirement? 25.
25 KL, madam.
So where do I get that 25?
In our guidelines, madam,
Where?
the
There are too many documents out there,
yeah, madam.
too many papers. out
Page 1, madam. Is it internal?
there. Where have I said? Was to have an expected to be opened by the respondent number 3. Pursuant to the notice dated so and in terms of the PSU Oil Marketing Companies Manual for selection of dealers for regular and rural retail outlets applicable to the respondent number 3, 4 and HP is
HPCL.
and HPCL and HPCL required the expected combined sales volume of the new rural ROs bracket E class to be 25 KL per month. On the other hand, the feasibility report done by the respondent number 3 for the new rural RO to be set up in person to the notice dated so and so showed that there would have been a combined expected combined sales volume of 63 kiloliters per month. he also submits that the office memorandum dated 6/4/2011, which has given guidelines for conducting feasibility study for opening new ROs, is applicable only to is not applicable to rural ROs and is applicable to other ROs. The next paragraph, the learned counsel for the respondent number 3 also submits that the petitioner being a third person, he has no legal right to make a challenge to the decision of the respondent number 3 to open a new RO on the basis of a feasibility study, which concerns only the respondent number 3. He accordingly submits that as the petitioner has no locus standi to challenge the decision of the respondent number 3 to open a new RO, the writ petition should be dismissed.
It's a part of Union Road Congress, madam. This is between two petrol pump in rural area, is 300 meter.
But you have not given me you give me the page 3, you have given me page 2 only, page 4 only, give me page 3.
Yes.
Madam, you have given me page 4, give me page 3. I want to see what's written. Give me 1, 2, 3. To subtext. I have heard the learned counsel for the parties. The issue is with regard to whether the feasibility report made by the respondent number 3 for opening a new RO required the respondent number 3 to take into consideration the sale output of the petitioner's petrol pump, besides the 2 petrol pumps that it had considered in its feasibility report, one of which was a petrol pump under the IOC. Bracket respondent number 4 and 5. Full stop. This is made by whom?
It's a committee, my lord, of the government of India, my lord. Union Road Congress, my lord. But it is not notified in Assam, my lord.
Not notified me, sir.
It has been notified by Madam Government of Assam. Madam.
Okay.
It is an application, Madam.
Right.
It's a guideline basis.
In the guidelines for access, location and layout of roadside fuel stations and service stations. Made by the Indian Road Congress. And which has not been made applicable to the state of Assam, comma. Well, where does it say that the distance between fuel stations should be dispatched? It has been stated that the distance for setting up fuel stations along rural roads in plain rolling terrain can be reduced to 300 meters in place of 1,000 meters, depending on the level of traffic. As per the above, comma, there has to be a distance of 1,000 meters, comma, that is 1 kilometer between two petrol stations in rural roads in the state of Assam. So, the feasibility report made by the respondent number 3 shows that there is around 1.8 kilometers distance between the new RO to be set up by the respondent number 3 and the petitioner's petrol station. Next paragraph.
But not petitioner. That is I very minor, not petitioner.
No. Petty,
Feasibility
you
has
see,
been-
you see,
173.
no. Let us come to 173.
Yes,
Your petrol pump is across the road. There is a T. There is a T. Your is here.
0.
Yes, you see this P is the new RO.
Yes, right.
That P to the main highway is
Yeah.
1.8 kilometers.
Yes, right.
And your petrol pump is on the other side of the road.
No,
I think
it
highway.
is- this petrol pump is here itself, my petrol pump, not the other side.
It is along this rural road,
Yes, this is along,
is it?
which is my lord, that's why I'm saying.
It is clarified by Madam.
Huh?
I was saying,
No,
Here, my petrol pump is not in this map, that is what I am saying.
no, but you see, I have made this mark
Yes,
earlier. This red mark is here.
Here.
And this is the indication that you all have given me on the last time.
my lord, this is, I think it's not correct. My petrol pump,
Ah.
my petrol pump,
And is according to where is it?
yes, it is, I have given a statement also.
No, where
Yes.
is it? According to you, show me.
This is according to me, my lord. That number, your lordship will kindly see the 1.8 kilometer, that's a Patali Doha road. This is straight coming here is Patali Doha road. So from highway, my petrol pump is 1 kilometers from highway.
Okay, so it's 800,
Yes.
800 meters.
Correct, correct. They considered 0.0 kilometers one, kindly see one. 4.0, that is one, that is Chinese service station. And this, but they did not consider 800 meters, they are not considering. It will be a total different equation if they would consider. Intentionally, they left out. Otherwise, what was the point? They
And
didn't
one
consider.
is far away.
Yes, one is far away, 5 kilometers. 5 kilometers.
And no, what about AIE Valley Service Station?
That is-
Two is pretty
Yes,
close.
yes, 0.2 kilometers.
That is above
Yes,
1.8,
yes.
above above 1 kilometer.
Yes,
Yours is only 800.
800 meters.
So what have we said? Show show that between the new RO and the main and NH 27 and NH 27. So stuff. However, as per the submission made by the petitioners council, the distance between the new RO to be made by PW3, no, by the respondent number 3. And the petitioner's petrol pump is around 800 meters, which is situated along the Patila Daha Road. Yes, is that a fact? Because if it is 800, then it will come within that 1000. And it is nearer to all the other petrol pumps. So on the other hand, the feasibility report has considered one Chinese service station. Chinese, it's IOC.
This IOC.
Chinese service station,
Saini-
SAINI.
Saini BPC and
Service
IAI
station,
Valley Station.
bracket, BPC
Yes,
and BPC, which is
5.8.
which is around
5.8 kilometers.
which is 5.8 kilometers away, and AIE Valley Service Station bracket IOC,
IOC.
comma, which is 1.6 kilometers away. Full stop. Next para. Yes, you obtain instruction with regard to this. Then Mr. Bor Thakur will obtain the instruction with regard to the distance between the petitioner's petrol pump and
Proposed.
the proposed new RO by the name. Otherwise, you have everything in your favor. Only problem is now his petrol pump is the closest.
Page 60 minute is says that 4 kilometer,
Wait.
page 16 minute.
Of the petition. 16.
Instead from 15, had this exercise been carried out as required, then the new retail outlet would not have been proposed to be set up by the Bharat Petroleum Corporation Limited, Pati Daha, only 5 kilometers from so and so. From intersection from
Advertisement.
of the existing retail outlet of petitioner, which is located within 4 kilometers.
Correct. But I want to know the distance between your petrol pump, new petrol pump, proposed new petrol and his petrol pump, because he says it is within 1 kilometer. 1 kilometer can be 900 meters also. If it is 900 meters, then there's 900 meters difference between your new pump and his pump.
Then also there is no prohibition.
Huh?
If it is within that 1 kilometer also, there is no prohibition to set up a new petrol pump.
There is no prohibition. I'm not saying there's a prohibition, but then your action doesn't seem to be fair. When it's like this, you want to set up an ice cream shop. You are considering an ice cream shop 5 kilometers away and 3 kilometers away, but not considering an ice cream shop which is just 10 meters away.
Probably when he is earning more my lord than the other my lord, petrol pump my lord, because they are earning 22 my lord KL per month. My lord. He is earning my lord 50 to 60 KL per
Maybe
month.
whatever.
That's why my lord.
Yes, fine. We'll give you a short date, Monday. Monday. This is the matter of month. This is the matter. You probably type out all this. Huh? Yes, take all this, my God, there's so much loose paper. I feel like just throwing it
He should be penalized. He made all this paper.
all loose papers. You all are giving us paper.
Is against me, my lord. I have to have more cautious, my lord.
You see, I mean, both of you have got points. Legally, I think stronger, prima facie. But then your action doesn't seem to be, above board.
No, I cannot make a concept, my lord.
I know, no, so that is why I just want you to just see the distance. And then also think of why don't have a new feasibility report? How does it matter?
This would have better for him also, my lord.
It clears up
All.
the entire thing.
Yeah, my lord, it's gone. Finished,
Once-
my lord.
once-
Yeah, once it is
Once
done,
you show that after considering him, you are still entitled, you'll still get 25 kiloliters. Then end of the matter, nothing to
it
say.
doesn't matter.
And there's a disputed question of fact.
Yes.
If he wants to challenge that, he has to go
Have
to
to go for
civil court. And there also, how will he prove it unless that RO is set up?
I'll tell my client, don't come, go to the civil court, do whatever you want to do it. Deeply open.
There be no. There be no. Yes, madam, any objection to the review petition?
No, my lord, I have prepared this review petition.
Oh, any objection, madam?
No, my lord, only thing is this, in the judgment, my lord, only one word is there, that is master role. In fact,
So we'll clarify,
yes, my
we'll
lord,
clarify because
Yes.
they are saying that the directions will not be disturbed.
yes, my lord,
So, and para 22
yes, my
of that judgment
judgment, my lord, yes.
says that master role work charge and similarly placed work.
Yes, yes.
So that will come up.
Yes. Yes, my lord. Yes.
Okay, right. Heard. Miss R.S. Jury, learned counsel for the review petitioners. And Mrs.
NS Thakuria,
N.S. Thakuria, learned counsel for the respondent.
yes, my lord.
Pusta. The counsel for the review petitioner submits that the order dated 16/9/22 passed in WPC 5290/2020 needs to be interfered with. You just take this last order at 14/3/2023. You just first paragraph, okay? Miss N.S. Thakuria, learned counsel, for the respondent, submits that she has no objection to the prayer made by the review petitioners counsel. So long as the writ petitioner is given the minimum scale of pay.
My lord.
Full stop. However, as the impugned order dated 16/9/2022. No, full stop. That's all, nothing, full stop. On considering the submissions made by the councils for the parties, comma, this court is of the view that the review petition should be allowed, in as much as the petitioner is a daily wage worker and not a master role worker, as had been initially made out by the petitioner in the writ petition. Full stop. The above being said, para 22 of the judgment and order dated 8/6/2017, passed in WA number 45/2014, had directed that had directed the state government to pay the minimum of the pay scale to master role workers, work charge workers, and similarly placed employees working since the last more than 10 years, bracket not in sanctioned post, bracket close, with effect from 1/8/2007. As similarly placed employees mentioned in para 22 of the judgment and order dated 8/6/2017, passed in WA number 45 of 2014, would also include the writ petitioner, as has been submitted by Ms. R.S. Dury, learned counsel for the review petitioner, this court directs that the state respondents to pay to the petitioner the minimum scale of pay as provided in the office order number 200 dated 7/11/2019, issued by the director, soil conservation, Assam, and the subsequent revision of the said pay scale, in terms of office order number 200 dated 7/11/2019. The pay/arrear pay should be released to the petitioner within a period of 3 months from the date of receipt of a certified copy of this order. The review petition is accordingly allowed. Make it 2 months, I think. 2
My
months, make it 2 months.
2 months. Well, 3 months, my lord.
No, your review also allowed 2 months. We have allowed your review. The review petition is accordingly allowed and disposed of.
Deeply obliged, my lord.
Yes, Mr. Islam, long time haven't seen you.
My lord, father of the petitioner, my lord, injured by bullets in the both of knees, my lord.
But where is the finding that he is permanently disabled?
My lord, due to shooted by the police, my lord, he is injured, but that should be given, that certificate should be given as permanent disabled, but that was issued in only injury is written, my lord.
Why? So why don't you go to the DC? Let the DC give will give a direction to the DC to specifically state
My lord.
whether you have been permanently disabled or not, because he has not made a tick mark, no.
Then by giving this.
I think that way.
This direction might be done.
Yes, who is appearing?
He have to approach Lordship the social welfare department, whether he is the disabled person or not, that can be.
No, the DC has to make the decision.
DC.
Physically challenged person, they have to have a.
Not physically challenged.
No, if it is,
Then there is the foreigners movement, that preferential
no,
appointment.
for disabled person, he has to have a certificate, ID card of disability, you know. That certificate indicates the percentage of disability and all. Deputy Commissioner has no authority.
No, but then as per the law, as per the rule, the
That's-
preferential, where is that rule?
That 90, yes, 92 rules.
Yes, as per the 92 rule,
Lordship.
it is the DC who has to give the certificate.
DC will give certificate as regard the victim of that particular, he is a family member of the victim of that incident, Assam agitation. That certificate he will give. That he is a family member of a person of affected in that.
But it was given to him earlier.
It is given, but the physical disability, as regard the disability of the person, that certificate has to be given by.
Then let the DC say that. Let the DC say that.
Lordship.
Well, because right now he's come against the DC's certificate.
Lordship.
Why should we send him on a merry-go-round? Let the DC say. it. Right. Heard Mr. B. Islam, learned counsel for the petitioner, review petition, who submits that the order dated 13/6/22 passed in WPC 3099/2022 dismissing the writ petition should be reviewed. Next part. The petitioner, the facts of the case is that the petitioner had initially approached this court. Acha, one thing, Mr. Counsel. Where is the division bench order?
Well, in the annexure,
Page 20.
page 90 to 21. Of the review petition. Annexure 5.
You see, this medical certificate
My lord.
at page 8, it does not say that you are physically disabled. It only says that you were shot.
My lord.
After this, he's saying that you're dancing, you're running around. See,
But both the knees are that.
so what? Then he says that you're dancing and running around.
But.
Page 8.
My lord, page 8, my lord. Injuries to both knees on 24 to 1983. This is to certify that Sri Keshav Chandra Bora, son of Sri Gokul Chandra Bora.
You were shot in both the knees,
My lord, my lord.
but you were under treatment for only 1 to 4 days, 5 days, only for 5 days.
My lord.
Even he was in the PAC, not in the civil hospital.
And Mr. Counsel, this is a false certificate.
My lord, direction may be given after inquiry, it is found.
I'll tell you why it is a false certificate. Can you guess why?
It was issued in 86. After below the signature,
It was issued in 86 maybe, but more than that. A very pertinent point.
Lordship.
Look at the date of the
Yes, 83, 29/2. Leap year.
leap year does not come in an odd number.
83,
Leap year will always be in an even number.
even number.
Even then, suppose one person was bullet into, my lord, can it be, my lord, there?
I thought that will give you something to do.
4 days.
This is a completely false, this is a fake medical certificate.
And even then, Lordship, may kindly see the
Huh?
annexure 11, page 3, Lordship. Due to bullet injury, Lordship, may
Annexure
last-
11,
Lordship, page 11.
page 11.
Last line of the. Due to bullet injury, they admitted in the civil GMC is from so and so, so and so.
That the certificate issued by the.
And my lord, this is given by the, my lord, the ASU. all Assam student union service. This and that certificate extra one page.
Annexure 1, page 8.
Page 8 and 11 are contradictory.
Contradictory.
He said he was under treatment at Samaguri and they said under treatment at GMCH.
Which one is correct?
I don't know. But one thing is, I'm very sure there cannot be a leap year. There cannot be a 29 February in a odd year. It has to be in a even year.
Correct.
It will have to be in 1984. Cannot be in 83.
Correct.
I don't know which calendar you are following, but it doesn't appear that we are following the same calendar.
In the clause, method, it is by written by letter word method, HTTP method.
I think we're dismissing a case. Yeah, right. What have we said? The fact, the case is that the petitioner had filed WPC 3099/2022, praying for a direction to be issued to the respondent government to give the petitioner preferential appointment in terms of Rule 4 of the Assam Public Services bracket preferential appointment bracket close rules, 1999. Thereafter referred to as the 1999 rules. The petitioner had made the prayer on the basis of a certificate dated 16/2/2017 issued by the Deputy Commissioner Nogong, which stated that the petitioner's father had been injured in connection with his participation in the Assam movement on the problem of foreigners. A reading of the provision next paragraph. The provisions of the 1999 rules defined an affected candidate to mean a candidate who was a member of the family of a martyr or a member of a family of a person, who had been rendered physically disabled and possessed a certificate to that effect issued by the Deputy Commissioner of the respective district in such form as specified in the schedule to the 1999 rules. Next para. You take in the judgment of the writ petition judgment, para 8. Then para 9. This court dismissed the writ petition on the ground that the certificate issued by the Deputy Commissioner's office in respect of the petitioner had not been made in terms of the schedule appended to the 1999 rules. Further, there was no medical certificate in the writ petition to enable this court to come to a finding as to the injury suffered by the petitioner's father and as to whether the petitioner's father suffered any total physical disablement.
This court thus held that there was nothing to show that there was any injury sustained by the petitioner's father, which had led to total disablement of the petitioner's father. Next paragraph. The review petitioner thereafter filed an appeal, that is WA number 33/2023 before the division bench, stating that the review petitioner had now been able to lay her hand on a medical certificate proving that the petitioner's father had been proving that the petitioner's father's both knees had received gunshot injuries. First up. WA number 33/2023 was in the next para, was disposed of as withdrawn, with liberty being given to the petitioner to file a review petition before this court by annexing the medical certificate of the petitioner's father. The next para, Mr. B. Islam, the learned counsel for the review petitioner, submits that as the medical certificate clearly shows that the petitioner's father had received gunshot injuries to both his knees on 24/2/83, and that he was under medical treatment from 29/2/83 to 5/3/83. And this 83 also, it is not only in letters, in words also. So there is no typographical error.
Right.
What do I say? The same clearly proved that the petitioner's father had suffered physical permanent disablement to stop. Accordingly, the petitioner was eligible to be considered for preferential appointment in terms of the 1999 rules. So, next para. The counsels for the, Mr. Have I said in the beginning the names? Oh, Mr. B. Islam for the review petitioner, Mr. D. Nath for
1, 2, 3, and 6.
1, 2, 3, and 6, and Mr. J. Handik for
4 and 5.
4 and 5. Then at the now you're right. Mr. D. Nath and Mr. J. Handik, learned counsel for the respondent, submit that the medical certificate, bracket annexure 1, and the certificate dated 30/08/2000 issued by the All Assam Students Union, bracket annexure number, annexure 3, are at variance with each other, besides being fabricated documents. As such, the review petition should be dismissed. Correct? I have heard the learned counsel for the past. The medical certificate issued by one Dr. B. Saitya, Senior Medical and Health Officer in charge, Samaguri PHC, Nagaon, Assam, is to the effect that Shri Keshab Chandra Bora sustained gunshot injuries to both knees
on 24/2/83 and was under his treatment from 29/2/83 to 5/3/83. Full stop. The medical certificate is reproduced below as follows. Yeah, page 8. Next para. A perusal of the same shows that shows that the treatment was given from 29 to 1983. Besides the words 83 being written in numbers, comma, it has also been typed out in words. The above being said, comma, there was no leap year. No, the above being said, comma, 1983 was not a leap year. And as such, the month of February would have had only 28 days and not 29 days. The doctor was the senior medical and health officer in charge of Samaguri PHC now, as per the medical certificate. Interestingly, the certificate issued by the All Assam Students Union, bracket Annexure 3, states that states that Shri says that Shri Keshab Chandra Bora, bracket petitioner's father, was admitted in GMCH from 29 to 83 to 5/3/83 due to bullet injury. It is not disputed. It is a known fact that GMCH stands for Guwahati Medical College and Hospital, which is located in Guwahati city. While Nagaon is the capital of Nagaon district. The same mistake as has been made in the medical certificate with regard to the date of treatment has also been made in the certificate allegedly issued by the All Assam Students Union. The above facts clearly show that the medical certificate and the certificate issued by the All Assam Students Unions are fabricated documents. As such, this court does not find any ground to interfere with the impugned order dated 13/6/2022 passed in WPC 3099/2022. Those are the the review petitions accordingly dismissed. Next. Yes. So this has caused problem to you, not to you, to others.
Lordship. Well, the whole order has already been set aside, Lordship.
So it should not be set aside the whole order.
We are concerned in regards to only 3 villages under Hailakandi bypass, Lordship.
Okay, what are the 3 villages?
Lordship, Narayanpur part 3,
Narayanpur, part 3,
Gangpar Dhumkar part 3.
Huh?
Gong, G-A-N-G-P-A-R, Gong.
Where is the spelling? Or is it?
G-A-N-G.
No, where is it in your petition?
In the synopsis, I have lordship, and line 7 lordship. In the synopsis, lordship.
And Vichinga, part 1.
And this is the part of it.
So, but all the persons in these 3 villages, they want that the order should be set aside only with respect to these 3.
Lordship, I mean, that much lordship.
Any objection? No. No, okay, right. Right, Mr.
R. Pupon lordship.
R.
R. Pupon.
Pukar, learned counsel for the petitioner, review petitioner. Who submits that the impugned order dated 28/3/2023 passed in WPC number 1452/2021 should be reviewed in as much as this court had set aside
Paragraph 12, lordship, and 13.
the impugned order dated 1/7/2019 passed by the respondent number 6 in its entirety, while the affected, while the writ petitioners who were affected by the impugned order were limited only to the 3 villages, namely Narayanpur Part 3, Gangpardum Kar Part 3, and Vichinga Part 1. Synopsis of these 3 names. The petitioner's counsel submits that the petitioner is concerned only about no, is concerned about the no, it was concerned about the impugned order only with respect to the above 3 villages under the Hailakandi bypass, and not with regard to the effect of the impugned order in respect of other areas covered by. He accordingly submits that the setting aside of the impugned order dated 1/7/2019 issued by the respondent number 6 should accordingly be limited only to those writ petitioners who were affected by it and whose lands were covered, whose lands were located in the areas covered by the above 3 villages. Correct? Next. Miss R. Devi, learned
For one lordship.
CDC
CDC law.
appearing for respondent number 1, Mr.
R. Boro on behalf of C. Boro.
Mr. R. Boro appearing, or R. Bora,
Boro,
R. Boro, B-O-R-O, appearing on behalf of
C. Boro.
Mr. C. Barwa,
For respondent number
B-A-R-U-A-H, A-H, for respondent number
3.
3, and Mr. J. Handik appearing for
6 and 7.
respondent number 6 and 7. Anybody else?
I'm for 1 and 2 lordship. I'm for 1
Acha,
and
Miss
2.
R. Devi for 1 and 2.
Yep.
And Mr. D. Nath appearing for respondent number 4 and 5. Submit that they do not have any objection if the review petition is allowed by limiting
by limiting the setting aside of the impugned order dated 1/7/2019 to the writ petitioners whose lands were affected and covered by the three villages. That is census. Next one. In view of the submissions made by the council for the parties. This, the earlier order dated 28/3/2023 passed in WPC 1452/2021 is hereby recalled and modified to the extent that the setting aside of the impugned order dated 1/7/2019 passed by the respondent number 6. Will only be in relation to the lands of the writ petitioners under the three villages, namely so. That's all. The review petition is accordingly disposed of, is allowed and accordingly disposed of.
May I say one thing, Lord? There is a direction in paragraph 13, Lord.
Okay. And next paragraph, before disposal of, we just say, consequently, the respondent number 6 is directed to make a. Now you just take this para 13, para 13 of the order. Then at the bottom, we say next, we say, the review petition is disposed of and is allowed and accordingly disposed of.
Obliged.
Made lordship, I seeking extension lordship. In terms of the order dated 29/3/2023, petitioner was directed to submit a appeal before the district judge Kalpi Anglong. Due to personal inconvenience, they could not submit this same.
That is the issue. Okay, so how much time do you need now?
3 weeks time.
With effect from today?
With effect from today. State 18.
Right. Third, Mr.
J.M. Sulaiman.
J.M. Sulaiman, learned counsel for the applicant who submits that in terms of the order dated 29/3/23 passed in WPC 1749/2023, the applicant had been given the liberty to file an appeal before the district judge Karbi Anglong at Difu within a period of 3 weeks. However, the applicant has not been able to file the same within the stipulated time period due to what? Due to
Personal difficulties.
due to personal difficulties. He accordingly praised that the applicant should be given a further 3 weeks time with effect from today to file an appeal petition in terms of the order dated 29/3/23 passed in WPC 1749/2023. Yes, to the forest department, Mr. Gogoi was here. Forest. No, wait, Karbi Anglong and Please call them, call them. Karbi Anglong. Who was there earlier? DOI was there and Ken Pry, S. Ken Pry. Do you know them? DOI and S. Ken Pry, you call them. I will wait here for you. Yes, next. Yes,
On 15/5/23, Lordship has directed the authorities to initiate the NIT
yes.
and to complete the entire process within 2 months.
Ah,
By this time, the NIT has come up. NIT has been issued on 20th of July,
28.
27, 2023. Under what circumstances it could not be done, we have explained in the IA. Now, they have prayed that Lordship will grant us time till September 15. By that time,
September 15.
15, they will do. The NIT says the last date for submission of NIT is 22/8/23.
22/8.
22/8. 1 month. time.
So 22/8.
Lordship.
So 22/8, then when will you select? By 31st August?
By 31st of August, DC will do his part. Then DC has to send it to the government. Ultimately, the order will be issued by the government.
So let it be done by 15th September.
15 seconds.
Entire exercise. Yes.
Entire, Lordship is directed to do the entire. I'm
Okay, right.
placing the NIT before you.
Mr. Deena, learned counsel for the applicant, submits that in terms of the order dated 15/5/23, passed in WPC number
Page 20 is the order.
passed in WPC 728/2022, comma, WPC 520/2022, and WPC 1637/2022. The state respondents were directed to
Paragraph 5, page 20.
make regular settlement of the fishery within 1 month from 15/5/2023 and complete the entire selection process, comma, by issuing an NIT and selecting the successful tenderer within a further period of 1 month. Full stop. Next paragraph. They have stopped the fishery.
Yes, yes.
Full stop.
Government has passed the order. I have any explain.
Further, the present arrangement of running the fishery was to continue only till 15/7/2023. Full stop. Next
Please.
paragraph.
Page 25.
Mr. Deena, learned counsel for the applicant submits that no one is running the fishery, no private party is running the fishery. Or is the fishery closed? What do you say?
Government has passed the order. Page 25, can you see?
Page 25.
Page 25.
Yes, yeah. And you cut that, don't say anything. Cut that. That's right. Mr. Deena submits that NIT for regular settlement of the fishery has been issued. This is as if I cannot read. Issued on
At the top.
27,
27, 20.
20/07/2023.
Yes.
And the last date for submitting applications is 22. Submitting bids is 22/8/23. He accordingly prays for time till 15/9/23 to complete the entire process, comma, including the selection of the successful tender in terms of the advertisement. He also submits that
Page 25, the operating portion, last para.
Further, in the meantime, fishing activities in the said fishery may be stopped after 15th of July as per the honorable court order and possession of the
Submits
fishery
that
may be
as
taken
per
over.
the order dated 7/6/2023 issued by the Deputy Commissioner Tinsukia. No, no, it's
This is
submits that it in terms of the letter dated
This is 3/6/23,
3/6/23 issued by the respondent number,
Joint Secretary to the Government of Assam.
that is respondent number.
In the writ petition.
Is not here, okay. Issued by the Joint Secretary to the Government of Assam, Fishery Department. Fishing activities in the fishery was to be stopped after 15 July 2020. Next paragraph. Mr. L. Fukan Mohan appears for the
Writ petitioner in WPC 420 and 160.
appears for the writ petitioners in
WPC 520,
5/20/2022 and
1637.
1637/2020.
My humble submission is that already the respondent has there is a honorable court has directed to complete a process within a period of 1 month, but they are causing the obstruction because they are issuing a notice from the by the DFO saying that the so far the fishery part is concerned, your lordship, it is falls within the eco-sensitive zone. That is why they have issued a notification. Then we have challenged this by filing a writ petition. Honorable court state that part. That is why delay has been occurred. So my humble submission, no further time will be entered.
Submits that no further time should be granted beyond the extension prayed for by Mr. Dina. On considering the submission made by the council for the parties, the state respondents, the applicants are granted time till 15/9/2023 to make regular settlement of the fishery in terms of the NIT dated 20/07/2023,
Including handover possession lordship. So far,
including hand.
Government will pass the order. Handing over is again will
again, Deputy Commissioner, this is
This
also
will-
come within the order. That is why lordship.
Including handing over
The
the fishery to the concerned, to the selected tenderer by 15/9/2020.
they will complete the process.
The application is accordingly allowed and disposed of.
Lodge.
Just right, before that, you write, the copy of the NIT dated 20/07/2023 is made a part of the record and marked as Annexure X.
Lodge.
Yes.
Lodge.
See? Yes, but what did I say? Item 7, I had made some, just read it.
Yes.
Okay, right. Mr. D. Gogoi, appearing for the Forest Department, submits that he has got no objection to the prayer made by the applicant. Full stop. On considering the contents of the application and keeping in view the submission made by Mr. D. Gogoi, the applicant is granted 3 more weeks to file an appeal petition in terms of the order dated 29/3/23 passed in WPC 1749/2023 with effect from today. To be counted, to be with effect from today. The I is allowed and accordingly disposed of. So I haven't seen you all for quite some time now.
This bench lordship is taking up, madam.
Ah.
This, we're not very used to that bench, madam. Your lordship, how does the bench lordship will see us regularly?
And now this criminal bench is quite different from the bench that we used to take up earlier. Out here, we've got to listen a lot.
Yes.
Because liberty is involved and they've been convicted and sentenced for
For
10
life.
years and above their life, 20 years, 15 years. And they're entirely different. Cannot dispose of in short orders.
Yes.
Yes, yes. Okay.